removing the petitioner from the office of the president of 13 Kathuri Gao Panchayat. The councils appearing on behalf of the petitioner, both in the writ petition as well as in the interlocutory application, submits that the matter has become infructuous, taking into account.
I am not saying this.
You are not
In
saying.
my opinion, because that is a violation of section 15(1) of the Panchayat Act, because there was no two-third majority. Only 7 members expressed no conviction. That is one aspect of the case. Another section 15(3), where the president should have been given an opportunity of being had, that was not given. So I am not saying that. It may be my learning.
They have also withdrawn that proposal also, no confidence. That petition disposed of 5091.
Where is that?
WPC 4112/22, the said persons, the said members file one writ petition. All the members of the government set file one writ petition jointly to recall the no confidence. But Justice observed that no, it is not permissible in law. Once it is removed, you better file submit application before the authority, CO, Chief Executive Officer. We submitted the application. Subsequently,
We means.
these members.
So why you are we?
Yes, and subsequently, I also filed one writ petition.
Okay.
Myself also filed 5091. That has been also disposed of, but as it is removed and writ petition is pending, it was missing file. That's why in this way, her political career,
May I submit one proposal? Because file is with me, and my director is saying I am the lawyer of the petitioner. So matter may can be listed tomorrow. We will take instruction from party who is their lawyer actually. Then we will have.
No, didn't you appear with a no objection certificate?
At the time, after taking no objection certificate, I appeared at that time.
Where is the no objection certificate?
That is highly taken away by decline me from me also.
And file is now with me. So that is that.
Okay, then remove it. You are gone. Yes, Mr. Mahmood, you say. If the file has been taken away, you have no letter.
Yes, yes.
Better we have a.
No. You tell me what is your.
There was a no confidence motion. After crossing the barriers of section 15(2) of the Panchayat Act, matter and 3, and thereafter 4, thereafter went to Anchalik Panchayat. Anchalik Panchayat held the meeting.
Show me which is the date of requisition when it was made.
Yes, that is kindly see page 26 in the imperial order.
Page 26. This is the requisition made.
Yes. Now,
The aforesaid attendees at 11 a.m. in the morning held the
Yes.
meeting as per
Yes.
the order of so and so.
now operative question maybe in page 27 bottom. So after casting votes, the ballot box is open in the presence of Shafiqul Islam, GPC Kathuri, Gao Panchayat, along with all others, and started counting in front of President and Secretary. Thereafter, total 7 ballot papers are gone in favor of no confidence motion against the President. After the counting, after that, the President declared that the no confidence motion against President of 13 number Kathuri Gao Panchayat is adopted. Now, thing is this: these 7 persons cannot do because my Lord may kindly see the provision of section 15(1).
Eh, Muke Khon Dioksun. Panchayat Act. Yes, what does 15(1) say?
Yes, 15(1) says, my Lord, every president or vice president shall be deemed to have vacated his office forthwith when the resolution expressing want of confidence in him is passed by a majority of 2/3. So 2/3 majority is required. 7 is not 2/3
Why you are saying?
because there are 13 members. There are 13 members, so single majority. So the no confidence motion is violation of mandatory provisions of law. And Lordship is aware, every provision of Panchayat Act is mandatory, not directory. There are
What is your basis? You are saying 15 members?
13 members.
No, how are you saying 13 members?
No, actually, I took the instruction, this is says,
No, your instruction won't do.
but normally.
If we are to strictly,
normally 11
no,
11 or
because
11.
that day I got one panchayat matter where the total member was 10.
10 president 11.
Then what is your basis to say 13?
That is not mentioned here.
If you have not mentioned, then how can you say it to be not?
Total member, my learned friend may also say, because here.
Yes, Mr.
just
Datta.
Total
How many
members,
members?
yes, 10 members.
10 members. Matter ends. Then
How many members?
10.
10.
10 is 2/3. 7 is 2/3.
Yes. If 10, that is 2/3.
So that question goes next.
And next thing is this one, section 15(3),
Hmm.
proviso.
Value. Yes.
Here, let's see, page 16(3) proviso, provided that no such president or vice president of a government shall be removed from the office unless he is given a reasonable opportunity to furnish explanation to the Anchalik Panchayat. Now, they did not serve copy on the basis of which the motion was moved against me. What were the allegations? Those were not furnished to me. Secondly, I was given no chance to explain my position.
Now, are you saying the requisition form was not given to you? If your requisition form is not given to you, where is the question of contravention? Wouldn't that be automatically a contravention under section 15(1)?
No, that is my case, that I was not given chance to explain my position.
No, you were absent.
No, I was absent. No, that kindly see now page 28 there.
Yes.
I filed a petition immediately.
Ah.
That page 28. it
Page
says-
28 is not there. Nothing is there.
No, I am saying it discussed no contest motion. Thereafter, my petition may be seen page 31.
Hmm.
To the Honorable Secretary of the Kathari Gaon Panchayat, that is so-and-so, sir, prior to show cause for no confidence motion against the President without any reason. With due respect, I would like to state that according to the High Court order, a meeting was held on 18/10/21 under.
So you knew about it. If it was on the basis of a high court's order, you were aware of it.
I knew, but copy was not served.
Copy for what?
Copy on the basis of which no confidence motion was brought against me.
How is it? No. First and foremost, you are not alleging the violation of 15(1). 15(1) category 15, not 1, 15.
15(3).
15(1), the proviso. The second part of 15(1), which states that within 15 days you are to convene the meeting. So that obviously the fact that the High Court had directed, meaning thereby that you knew about what was the contents of the requisition.
I knew about that.
Then where is the question? You were not present, and when the High Court had directed the meeting or to be on so and so, unless you say that I was not allowed to enter, and for which you have filed an FIR, you have no case.
That is okay. I know about the date of the meeting,
Then
but the grounds on which I was sought to be removed, that was not,
the ground was obviously there in the requisition.
that was not there.
100% it has to be there.
But record.
No. The requisition was very much there. You had the knowledge. That is why there's a direction by this court.
But thing is this, when I wanted to know that what are the reasons for which I have been sought to be removed. that
Yes,
was
what
not-
is your name? Muzira Khatun. Muzira Khatun. Where is that Muzira Khatun?
No, it is also not there that they supplied. I think,
Muzira
but
Khatun. That
They
is there.
supplied the,
As agreed by the learned counsel for the parties and taking into consideration the subject matter, the present is disposed of. 8 numbers of petitioners have joined together. It is a case of the petitioner. They are all elected to 13 numbers of so and so. And respondent number 11 was elected as so and so. In the course of time, as per the version, the petitioner, the action of the respondent number 11 was not only conducive and against the welfare, there was also under such a petitioner had submitted a requisition notice dated demand for bringing in no confidence against the respondent. The said notice was received by the in charge Imam itself, who thereafter issued a letter dated to the president and the members intimating the date of no confidence dated so and so. Accordingly, on Imam, the meeting was convened in the office of so and so, but in the said meeting, the in charge so and so were not present with the oblique intention. Nonetheless, the resolution was, however, the petitioners could learn later on the in charge so and so informed the so and so to convey the memorandum. When the said meeting was convened, the president and 3 members were not present. However, so and so. I've heard Mr. J. Ahmed, the learned counsel for the Mr. M. Nath appearing, and Mr. B. Deori, the state counsel for the respondent so and so. Court had deemed notice upon the respondent to be complete. Such service was done through Dusty and an affidavit. However, chose not to appear. Since the contesting parties are present before this court is of the view that Secretary of so and so shall convene a meeting for so and so on Iman in the office of Iman at 11 a.m. The aforesaid date, time, and venue are fixed by this court as the contesting Iman so and so. So nothing remains. Heard Mr. M. Mahmood, the learned counsel, appearing on behalf of the petitioner. Mr. J. Ahmed appears on behalf of the respondent number 8. Mr. S. Datta appears on behalf of the respondent number
1, 3, 4, 6, and 7.
1, 3, 4, 6, and 7. Mr. N. Gusami appears for the respondent number 2. The instant writ petition has been filed by the petitioner challenging the no confidence motion, the resolution so adopted in the no confidence motion against the petitioner on 18/10/2021, as well as also the order dated 25/11/2021, whereby the office of the chief executive officer of the Gwalpara Jilla Parishad had accepted the resolution, the no confidence, accepted the resolution passed in the special meeting of no confidence against the petitioner, and empowered the vice president of the Gaon Panchayat to exercise all powers and perform all functions and discharge all duties of the president on removal of the petitioner as the president of the Gaon Panchayat. The learned counsel, appearing on behalf of the petitioner, raised 2 contentions. The first of such contention is on the basis of Section 15(1) of the Assam Panchayat Act 1994, to the effect that from a perusal of the resolution adopted on 18/10/2021, it is seen that only 7 members have voted against the petitioner. Therefore, the learned counsel for the petitioner therefore submitted that as there are 13 members of the said Gaon Panchayat, and as such, the mandate in terms with Section 15(1), which requires 2/3 majority for passing the resolution, was not done. On the other hand, Mr. S. Datta, learned counsel, appearing on behalf of the PNRD department, submits that the concerned Gaon Panchayat had only 10 members, taking into account the same, as 7 members have passed the resolution in favor of the no confidence motion. This court is of the opinion that the mandate of Section 15(1) was duly complied with. The second contention which have been raised by the learned counsel for the petitioner is that Section 15(3) of the Act of the Assam Panchayat Act 1994 mandates that the petitioner, that the president has to be given an opportunity to explain. However, the petitioner was not given that opportunity, for which the resolution so adopted on 18/10/2021 was in contravention to Section 15(3) of the Assam Panchayat Act 1994. It appears from the records that the meeting was held on 18/10/2021 on the basis of an order passed by this court, dated 29/2021 in WPC number 2513/2021. It further appears from the resolution adopted on 18/10/2021 that the petitioner chose not to remain absent in the meeting. So, under such circumstances, this court is therefore of the opinion that the question of contravention of section 15(3) of the Act of 1994 does not is misconceived. Considering the above, the instant writ petitions stand dismissed.
My one submission.
Pending applications, if any, stands dismissed. I এখন যোনখন আছে তাত লিখি দিব।
I have
In
one.
view of that above, in view of the dismissal of the writ petition, nothing survives in the.
I wanted my note that, no, that regarding that I had the knowledge. But opportunity was not given, that may be recorded in your order.
That I have stated, that is your submission. I categorically submitted that there was no opportunity granted,
Yes, yes.
and as such, it is a violation. That is what I recorded.
Yes.
Then I said that there is an order on the basis of which here, and you chose to remain absent, for which there cannot be the contravention under section 15(3) is misconceived. That is why I mentioned, I put your submission out there.
The thing is this, that regions must be supplied before 15 days. So that I will submit a letter.
Yes, next. Who is appearing in the next matter? 6035 of 2021. Yes, what is your case?
It is a logic. This matter pertains to non-payment of contractors' bill matter.
You have not got it?
No, your lordship.
Why you have not got it? How much it is?
1,55,034.
Are you verify? Make
Madam.
payment as per Tamsir Ali.
Lordship.
That ends. Heard, Mr.
R.A. Chaudhary.
R.A.
Chaudhary.
Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi appears on behalf of correspondent numbers 1,
1, 2, 4,
2,
5, 7, 8.
4, 5, 7, and 8.
Including 3, my lord. 3, 5 is final.
3 over Divo. And Mr. N. Gusami appears for respondent number 6. The case of the petitioner herein is that the petitioner was allotted various works by the respondent number 4, 5, 6, and 7. The petitioner claims to have completed the works and was entitled to an amount of rupees 1,55,034. In that regard, the executive engineer PWRD, Karimganj North, Karimganj South, and Badapur Territorial Road Division, Karimganj, had also prepared the first and the final bill in favor of the petitioner. It is the further case of the petitioner that the petitioner have intimated the respondent authorities have time and again approached the respondent authorities for payment of the said amount. However, the respondents have not paid. Under such circumstances, the instant writ petition has been filed claiming benefits similar to what have been directed by the full bench. The full bench, Tamsir Ali?
Yes, full one.
By the full bench in the case of Tamsir Ali and others versus the state of Assam and others reported in 2008 for GLT 1. It appears on record that the respondents have not filed any affidavit in the matter. Be that as it may, this court is of the opinion that the law as regards payment of contractual bills have been well settled by the full bench in the case of Tamsir Ali and others versus the state of Assam, but in the case of Tamsir Ali and others, Supra, wherein the manner in which such settlement of the bills has to be made have been specifically mentioned. Considering the above, this court therefore disposes of the instant writ petition with a direction to the respondent authorities, more particularly the respondent number
But here, Lordship may kindly see the last document, page 34. One will come from the revenue department.
Huh?
Respondent number, revenue is not a party, but deputy commissioner is a party, madam. Respondent 6. So you will
Directing,
see the last communication, annexure, page 34. So PWD has executed the work through the present petitioner.
directing he is the deputy commissioner.
Deputy commissioner as well as the revenue department.
Huh?
Respondent number 6, requisition has been made before the
Okay.
office of the deputy commissioner.
He लिख ले last line too. Respondent authorities and more particularly the respondent number 6
Yes, sir.
to verify the claims of the petitioner and thereupon applying the law laid down, applying the principles laid down in the case of Tamsir Ali. Grant and upon verification, if it is found that the petitioner is entitled to the said amount, by applying the principles laid down in the case of Tamsir Ali, grant the benefit to the petitioner to which he is entitled to. The said exercise be completed within a period of,
Well, in Tamsir Ali, my lord, direction is to my lord, insert the name in the chronological list. So accordingly, my lord, it will be paid. So tenure will be difficult, man. As per Tamsir Ali.
as per इतना लगे. And apply the, yeah, make verification and after where it is found, apply the principles as laid down in Tamsir Ali.
Lot.
With the above the condition standards.
Obliged.
Item 5,
We don't want to press this I.
Huh?
We don't want to press this I. Lordship.
You don't want to press this I?
Lordship, already Lordship has disposed of the main case and Lordship has made observation.
Which one?
The last page of the I. Lordship. Regarding this, we have challenged this order Lordship, during the pendency of the case. Lordship.
What I have disposed of? Have I disposed of or who has
Main
disposed of?
case, Lordship has disposed.
Which matter?
The writ petition Lordship.
The 6820 WPC. WPC 6820.
When?
23/5. 23/5 Lordship.
For what purpose?
Regarding eviction Lordship. Eviction Lordship.
Oh, that one.
Lordship, Lordship. You
You
have
got the order?
made
Yeah,
observation regarding this.
Oh, this judgment. Oh, you have got the benefit.
Lordship.
Chalo.
That's why we don't want to press.
Heard Mr.
J. Abbas.
J. Abbas, the learned counsel for the petitioner, Mr. N. Goswami appears for
2, 3 and 4. Lord.
respond numbers 2, 3 and 4. And Mr. for the revenue department. Gustav. The learned counsel for the applicant submits that in view of the judgment and order passed on 23/5/2023 in WPC number 6820/2021, the applicant does not wants to press the instant application. Considering that above the instant application, therefore stands disposed. Stands closed as withdrawn.
for admission item number 6.
Yes.
My lord, this case, in fact, my lord, was admitted long back.
Who are you?
I am a plaintiff petitioner, my lord.
What are you challenging?
Yes, my lord, I am challenging the order first by the district, the London district judge.
You are challenging an order by which you have been directed to be evicted.
Yes, my lord. No, I am landlord. My suit was dismissed. First, my suit was decreed by the court below on the point of default, but rejected the plea of bona fide requirement, against which the defendant preferred a title appeal before the London district judge. There I have filed a cross objections against the finding of the bona fide requirement. London judge decreed my suit not on the ground of default, but on the ground of bona fide requirement. Then they have prepared a revision before this honorable court. This honorable court remanded the letter before the London appellate court to decide all the issues afresh. Thereafter, the court, after hearing both the parties, dismissed my suit both on the ground of default and bona fide requirement, against which I have come before this honorable High Court, my lord.
এই মানে আজ কি করি কি আওয়াজ করি আওয়াজ দিয়ে করি একটু নাটক কম্পিউটার মানে টেকনিক্যাল মানে
This case was also listed on the manor Friday, my lord, and on the date,
you are the landlord.
I am the lord.
You had initially filed a suit
Yes, ma'am.
on the ground of defaulter and bona fide. Defaulter has gone for a 6. The remaining was bona fide. On the basis of bona fide requirement, the suit was decreed. After that, they filed an appeal. You
No,
filed a cross objection.
No, trial courts decreed the suit on the point of default.
The default, not on bona fide.
Bona fide,
Then you raised the cross objection on bona fide also.
Yes.
Now what happened then? The title suit was,
decreed on the ground of bona fide requirement.
but not on defaulter. So defaulter was held, that there was no default.
Okay, I'm not
But there was on the bona fide was allowed.
allowed.
Then there was a challenge made before this court. This court again remanded the matter back. And then it was decided bona fide was decided against you.
Both defaulter. Point of defaulter is also decided against me.
Okay, so now you are before this court. Yes. Now what is the ground?
Ground is.
Why you don't have bona fide requirement?
Ah.
Whose house it is?
My lord, this house, my lord, belongs
Let us see that particular option,
Ah.
the defaulter.
defaulter, my lord. Defaulter point, my lord, that my landlord came to a finding that he is not defaulter on the ground that my plea was this, my lord, that I have received the rent up to the month of June 1997. From the month of July 1997, they did not pay the rent. And they did not offer the rent.
Are we referring to page internal page 25? Internal page 25
Yes,
of the year or page
25, my lord.
107?
25, my lord, this issue. number
Kindly
one-
come to 107 of your document.
Yes, 107, my lord.
This
Issue
is the ground.
Issue number 5, my lord.
Decided the issue in learned
It is
counsel
fine,
and submit that the suit room has fallen vacant into the share of the plaintiff who has desired to come back to Bongaigaon and his business at Dajewar had fallen as such the suit premises was bona fide requirement of ordinance and coming of having a dispute in the Right. Whatever the plaintiff 1 and 2,
1 and 2, my lord. One was my father, and my father expired, my lord.
2,
2 is my brother, my lord.
he is expired.
No, 2 is alive, my lord. And 3 is also my brother, who is residing at the time. He was residing at Ghaziabad, and he was carrying on the business, but that business was closed due to the order of the Supreme Court that in the residential area, no commercial activities can be done, my lord. So he was not doing any business. So my father filed a suit in the court that I did this on a premises to start the business of my petition, that is 20 number 3, my lord. Now the landed appellate court held that I have failed to prove that the suit premises is bona fide, is required by me, and my need is.
No, you kindly come to page 109, what has been here.
109, my lord.
Hmm.
At page 109, my lord. So. that
Yes,
was-
Mr. Biswakarma.
Ah.
What is this law laid down by the appellate court? Is it the law? As far as 6 months back, as I remember, this can't be the law.
Lordship, the plaintiff and all, they are having a settled business
So what?
at Delhi, your lordship.
He says it is closed.
But to that effect, your lordship, the evidence was not led.
How are you surviving, Mr. Kansati?
My
Out
lord,
there in,
my wife is doing the service matter. She is in service matter.
who?
My wife, my lord. So from her income, I am serving.
So she's serving out there at Delhi.
Delhi. At Ghaziabad.
So you are going to be separated, both of you.
No.
When you come to
both
here-
of us will come at this Bogaigaon, my lord.
Huh?
Both of us will come at Bogaigaon, my lord.
So she will leave her job for a shop.
She will leave, my lord.
What type of area is this? How big is this area? That somebody is leaving a service?
This is my area, actually it is situated in the main town of Bogaigaon. Area is not about 245 square feet, but this is located in the prime area of the Bogaigaon town. So I want to do the business there. My brother, platinum number 2, is also carrying his business in the same business, but that was his one. So that's why I want to come back. But due to this matter, I could not come, and I am there. But I decided to come back. But due to the dismissal of my suit, I am not in a position, my lord. Because my business has been closed here. I have no other source of income.
And what does your wife do?
My she's in any company, my lord, in some company, my lord. And there she is doing the service, my lord. So from her income, my lord, my family is running, my lord. But I am not in a position to give the well education to my children also. That's why, my lord, I want to come back. That was the reason.
Did you issue notice to him that you needed it bona fide?
No, I mean, my father filed the suit, and we are also made the party. My father made the statement that this premises is needed for my son, President University, to start his business. But no notice was issued before them, but they knew this fact. my lord.
So what is your evidence that you are coming back to Guwahati,
No,
to Bongaigaon?
Bogaigaon, my lord, that was the evidence. my lord. I myself, plaintiff number 3 also gave the evidence, my lord.
Huh?
Plaintiff number 3, he also gave the evidence before the trial court.
Now that I have seen it, but what is your evidence?
My evidence is also there, man. I have also stated that my son wants to come back to here, Bogaigaon. That was the evidence, my lord. Reported a long back, my lord, in the year 2007. my lord. So that was our plea. But that was rejected by the court, referring the judgment of Supreme Court decided in the year 1974, my lord. In the Supreme Court 1974, it was decided that landlord must prove that his need is genuine, pressing, and bona fide. Referring, but thereafter, so many judgments, your lordship's law, in the Raghavendra Kumar case, my lord, that was decided in the year 2000.
Yes, Mr. Biswakarma, what do you have to say? Is it the law that one has to prove that he has to taken steps for setting up his business? Mr. Mukherjee?
Lordship, even in the plaint, your lordship, the fact of bona fide requirement is not there, lordship. It is they are only harping upon defaulting payment of rent in the plaint, your lordship. Lordship may peruse the plaint at page 20.
But when the matter was remanded back, he had filed a cross objection there
Yes, sir.
and it was remanded back to decide. Why was the issue framed if it was no bona fide, he was there. Why was he cross-examined that you have no, there is no bona fide requirement? Why he has made submissions, given evidence, and why haven't you put it under objection that it is not a part of the pleadings?
That was done, Your Lordship, and thereafter he failed to prove his bona fide requirement.
এইটো কি আবার যেটা কৰি থাকে এইটো no, there is another one. There's a screeching out sound. Get অশান্তি এইটো অকণ ডাঙৰ হৈ থাকে এতিয়া কমিছে বহুত দিগদাৰি yes
The issue number 5, Your Lordship,
I have seen it.
and it was repeatedly.
But the basis on which the court had come to the finding that he had, the basic was plaintiff has failed to show that he had taken steps to set up his business in the tenanted premises once the same is recovered. How can he have, without the tenanted premises, he has got it? Is he going to book, if he wants to give a just for, yes, Mr. Sanseti, what type of business you want to open?
That is the point on which this bona fide requirement is rejected. London court held that I did not disclose what type of business I am going to do there. I have not disclosed regarding my trading. That was also one of the point decided by the appellate court against me. But I think this, my lord, that I need that premises, and I shall decide that I have also stated when I shall.
But what type of business you want to do?
No, I want to do the business there, which has been there at Delhi, my lord, regarding this, my lord, escape business.
Did you mention it out there in?
No, I have not mentioned.
Then
That was not.
what
mentioned,
case
my
do you
lord.
have?
But my lord, I need this should premises. That was a fact, my lord. I have no other this premises that is also admitted.
But Mr. Sanjay, if I understood the fact that you want to have a business, fantastic.
Yes, my lord.
But the fact that you are going to have a particular business of a particular type, that only you should have stated out there. If you have not stated, make up your mind. I dismiss your petition, then make up your mind and file a fresh suit on bona fide requirement.
Because, my lord, suit was filed in the year 2000, my lord. In the year 2000. the
Obviously,
suit was
this
filed.
suit shouldn't have been so long.
My lord. So now there are so many circumstances changed. Now I want to start my business, my lord, because when the suit.
But
was-
how do I take care of that you want to do some business unless there is some evidence?
No, evidence is also there, my lord.
Where?
I have given my evidence.
Where?
In the.
No, there is no evidence out there. What till now you don't know what type of business you are going to do.
Because the evidence is close, my lord, in the year 2007. Thereafter suit was proceeding.
So better
Now,
off, I think you
2023,
file a
my
fresh
lord.
suit.
So I'm relying on the judgment of Honorable Supreme Court that the landlord is the best judge to decide which premises is required, my lord. Because I am the landlord now, my lord, and I need the premises. So, my lord, as for the judgment of Supreme Court, decided in the year 2000, again in another case decided by the Supreme Court, that the landlord need not to prove that what type of business he want to do. If he needs
Show me that judgment.
judgment, my lord, first, my lord, this Honorable.
How many years you have been there, Mr. Mukherjee?
Lordship,
From 1975, my lord.
70s,
From
1970s.
1975, our rent is only 280. From 1975 to till date, rent is only 275.
Because
From 1975. my lord.
enough. 180 in the prime locality.
If we are ready to pay enhanced rate, they are not cooperating. Your Lordship. The only thing is,
Enhanced rate from retrospective effect.
Lordship,
From
we are
2000 onwards?
ready to sit for a negotiation as well, but
Because this court,
for enhanced rate.
from somewhere, this court is
They are
today
neither
sitting out
fi-
there in bench one. Is it the reason why?
No, Lordship.
Then,
It was tried long back.
where is the judgment? This is the 2001.
Yes, my lord. That was the first judgment, my lord, 2001, Madhavendra Kumar. And my lord, I am relying paragraph 10, my lord, page 3, my lord. as page 3, paragraph 10, my lord. The learned single judge of the High Court, while promulgating first substantial question of law, proceeded on the basis that the plaintiff landlord admitted that there was a number of plots, shops, and houses in his possession. We have been taken through the judgment of the courts below, and we do not find any such admission. It is true that the plaintiff landlord in his evidence stated that there were numbers of other shops and houses belonging to him, but he made a categorical statement that his said house and shops were not vacant and that could be suitable for his business purpose. It is settled proposition of law that the land is the best of his requirement for residential or business purpose. He has got complete freedom in the matter. So here Malay Supreme Court held that only the plea was taken that was suitable for the person. But Supreme Court.
Where is my judgment on Rashmi Deka? Bush or that one judgment, you have it?
My lord, today I have.
Oh, you are not prepared.
My lord, I have.
No, I am only sitting for 2 days here. Why should I?
Another.
Let them also enjoy for some time. You have not got your judgment.
Your lordship knows everything.
I know everything, but why should I remember?
My lord,
Hello. Okay, some other date then. Let me not evict sitting only here for 2 days.
on the point of default also my lord, there. The suit was also.
Now you have a case. I was about to dispose, but you didn't get the judgment. That judgment is different. We'll have it.
On the day after tomorrow.
The day after tomorrow, I'm not sitting.
Then any day, as per.
I won't be taking up anymore. Matter, I'm here only for 2 days. 2 days, if you can escape yourself, you escape the tenants.
Another judgment.
Huh?
If your lordship goes through the point of default, what is the finding of the appellate court? Appellate court has stated, actually what happens, my lord, the landlord did not deposit the rent in court without offering to me. Appellate court held that the offering of the rent to the landlord is mere formality because there is the hostility between the parties. When there is a hostility between the parties, then this tenant can deposit the rent without offering the same to the landlord. And he has also deposited the rent in advance. The London Appellate Court held that was also in accordance with the law. So when the tenancy is month to month, they have also admitted that they have paid the rent to me. That was also plea taken by me. That was paid, has to be paid within 7 days. Then how they are depositing the rent in court in advance, 2 to 3 months, sometimes 6 months together. Huh? Sometimes 2 to 3 months together, or sometimes 6 months together. My lord, the tenant.
They are paying rent in that manner.
Yes, in that manner.
And has it been any finding arrived at?
Yes, yes.
That
Yes, that finding is there, my lord. And the
no,
law.
where's the finding out here in the appellate court? The judgment
Yes.
that they are paying in after 2-3 months.
And appellate court also held that the rent was offered sometimes 15 years back. So 100, at page 100, my lord, your lordship may come to page 100.
How does the court take note of it?
Yes, my lord. That is relevant
Defaulter
portion,
is
I
so
am
and so. On the other hand,
and,
unconscionable and respondents submit
this,
defendants are
default-
defaulter if they have deposited the monthly 2-3 months at a time by failing from time we can unconscionable drive home the point that in a case of extreme strain,
Page number-
landlord and any insistence on
105.
physical payment on demand, therefore the payment. Submitted the contract to the
It was paid in advance, Your Lordship.
So how do
2-3
you
months
pay in advance? How do you pay in advance?
Lordship, the
If you
finding
want to
was,
get the benefit under 5.4, how do you pay in advance?
Lordship, the finding was that, Your Lordship, initially, the plaintiff,
Where is the finding that you are not a defaulter? Kindly come to page 24, internal page 24, page 106. Hey, Rosmi, take up, go straight to the judgment. Very difficult, Mr. Sanchiti. You want to do a matter and then also you don't get the papers, judgments.
Lordship, initially the plaintiff number 1 was the owner of the property, Your Lordship. Then thereafter plaintiff number 2 and 3 joined and they claimed co-ownership. And under that circumstances, the defendant was bound to deposit the rent in the court. They tried to tender it to the plaintiff number 1 and plaintiff number 2 and 3. But due to the internal dispute, Your Lordship, it was, and over a period of time, Your Lordship, it was, the tenancy was from 1965, Your Lordship. And this custom continued for a long period of time, Your
No,
Lordship.
no. The moment you want to take the benefit of 5.4, you have to do it in that manner or not at all. That's the law. Can you have it like in this manner? Whatever you feel like you will do it. What is left then?
Lordship, what I suggest, can this matter be taken up at the end of the list today, Your Lordship?
Why?
It will take some time, Your Lordship.
What? I'm about to deliver the judgment. You are saying that what is the time? I'm only tracing out what is the judgment out there. As Mr. Sun City is not helping this court.
Lordship would accommodate me to search some judgments and assist the.
You don't require judgment. You go to take this judgment to the Supreme Court and then you get it corrected. But as for me, this is a matter to be dismissed right away.
At the end of the list, Your Lordship.
For what?
May hear the other matters and then.
No. Don't escape in this manner before this court. Where is that I'm not finding the judgment? The moment I get it, I'll. Second you, 2022 2 GLR page 64. Give it to me. Look, in the meantime, judgment to left. Heard, Mr. Two 2022 2 GLR page 64. Heard Mr. R.C. Sancheti, the learned counsel appearing on behalf of the petitioners, petitioners. Mr. B.J. Mukherjee appears on behalf of the respondents. Respondent. This is an application under section 115 of the Code of Civil Procedure 1908, for short, the code, challenging the judgment and decree dated 22/9/2017 passed by the Court of the Civil Judge Bongaigaon in title appeal number 35/2010, whereby the appeal was allowed, thereby setting aside the judgment and decree dated 5/8/2010 passed in title suit number 2/2000. The facts in brief. Are that the plaintiffs, are that the petitioners as plaintiffs had filed a suit before the court of, which court?
Municipal Court, Malok, at Bogaigaon.
Before the court of Munsif at Bongaigaon, which was registered and numbered as title suit number 2/2000. A perusal of the plaint, which stood amended from time to time, which was amended, reveals that the plaintiffs claims to be the owners of the room, which have been described in the schedule to the plaint. Full stop. It has been further mentioned that a room which have been described in the schedule to the plaintiff had fallen in the share of the plaintiff number 3. The defendant number 2 took the said suite room on rent for the purpose of carrying on the business of her shop. It has been mentioned that apart from the said room, he is in occupation of 2 rooms, 1 kitchen, 1 bathroom, and 1 latrine on the rear side of the first floor of the building of the plaintiffs. However, the said rooms However, it is only as regards the shop room on the ground floor, which is the subject matter of the dispute. It was alleged in the plaint that the defendant have been in occupation of the said room, hereinafter for short referred to as the scheduled premises, since 1975 as a monthly tenant. The rent of the said room, scheduled premises, was rupees 280. It has been alleged in the plaint that as per the agreement, the rent was to be paid within the 7th day of the next month. However, the defendant was always irregular. It was alleged that the defendant stopped payment of rent and started depositing the rent in the court since last many years without offering rent to the plaintiff or any of them. It was also mentioned that the deposits so made were not in accordance with Section 5(4) of the Assam Urban Area Rent Control Act 1972, for short, the Act of 1972. Inasmuch as there was no offer to the landlord and refusal of the landlord to accept the rent. It was also alleged that the rent was not deposited every month and rent for 2-3 months were deposited at a time. In paragraph number 5 of the said plaint, it has been further mentioned that the plaintiff number 3 was allotted the room which is under occupation, was allotted the scheduled premises which is presently in occupation of the defendant. Palale? Oh, goodness. It was mentioned that as the room was not available, that the plaintiff number 3 had to go to Ghaziabad, Suryanagar for starting his business in Delhi. However, his business at Delhi did not prosper, for which he intends to come back to Bongaigaon to start his own business in the room under the occupation of the defendant. Therefore, from a perusal of the plaint, it revealed that the eviction of the defendant was sought on 2 grounds. First, is the ground of bona fide requirement, and the second is the ground of defaulter in payment of the rent. It appears on record that the defendants had filed their written statement various preliminary objections were taken. In paragraph number 14, it was mentioned that the defendants are in occupation of the scheduled premises and the existing rent for the room in question was ₹280 per month. However, it was denied that the rent is payable within the first week of the next English calendar month as claimed. It was specifically, categorically mentioned in the said paragraph that the tenancy was created, inverted comma, that the tenancy was created under the plaintiff number 1. And later on, since the plaintiff number 2 and 3 also claimed ownership of the same, comma, the answering defendant have been regularly depositing the rent in the court in the name of all the plaintiffs after observing the necessary formalities as provided under the Assam Urban Area Rent Control Act, inverted comma closed. On the question of bona fide requirement, the defendant have stated in paragraph number 15 thereby denying to the statements made in paragraph number 5 of the plaint. It was mentioned that the so-called non-prospering of the business at Delhi is also a fake claim in as much as the plaintiff had shifted to Ghaziabad on his own with his entire family and is doing a roaring business there. And the plaintiffs have now come up with the fake plea that because of the alleged non-prospering of the business of the plaintiff number 3 at Delhi, he wants to start the business in the room occupied by the answering defendants. In paragraph number 16, it was mentioned that the answering defendants were never irregular in payment of the rent and have been regularly depositing the rent in the court after the rent was refused by the plaintiff number 1 on tender. It was further mentioned, it was admitted that the rent for 2-3 months have been deposited in the court at a time. But that does not mean that such deposit of rent in the court is not irregular. And the other allegations that the rent deposit applications were not accompanied by requisite court fee for notices and that notices to the landlords were not issued and that many rent deposit cases were dismissed for want of steps for service of notice are all false and baseless. Therefore, from a perusal of the written statement filed by the defendants, it would be apparent that there is an admission to the effect that there has been deposit of rent 2/3 months together. It is further seen from the written statement itself that it is the stand of the defendant that they started depositing the rent in the court when the plaintiff number one refused to accept rent. However, it is admitted that the scheduled premises that the said tendering of rent, that the deposit of rent was on account of but on the other hand, it is admitted that the deposit of rent before the court was on account of claim of ownership being made by the plaintiff number 2 and 3 over the scheduled premises. As regards the bona fide requirement, it has been duly mentioned that the plaintiff did not have bona fide requirements, and the plaintiff number 3 was having a roaring business at Ghaziabad, and the entire family of the plaintiff number 3 was having a roaring business at Ghaziabad. It further appears from the records that on the basis of the above pleadings, as many as 8 issues were framed, page 39 of Pagodi, which are as hereinafter. 9 issues were framed,
9 issues.
which are as hereinafter. On behalf of the plaintiff, Ale. On behalf of the plaintiff, there were 3 witnesses, and the plaintiff exhibited as many as 8 documents. On behalf of the defendant, there were also 3 witnesses, and the defendants exhibited various documents. Which were mostly the case records of rent deposit cases, the certified copy of the power of attorney, a certified copy of the judgment passed by this court in FA number 23/1981, as well as also certain treasury challans. The trial court, by the judgment and decree dated 5/8/2010, decreed the suit in favor of the plaintiffs. In doing so, the trial court decided both the issues pertaining to bona fide requirement. Hold on. Both decided the issue of defaulter in payment of rent in favor of the plaintiff. However, decided the issue pertaining to bona fide requirement against the plaintiff. Being aggrieved and dissatisfied, the respondent herein who was the defendant, preferred an appeal before the court of the civil judge Bongaigaon, which was registered and numbered as title appeal number 35 of 2010. In the said appeal, the petitioner herein, who was the plaintiff, also filed a cross objection. Being aggrieved by the determination of the issue pertaining to bona fide requirement against the plaintiff. The first appellate court, by judgment and decree dated 5/11/2013, disposed of the said appeal. By confirming, by affirming the judgment passed by the trial court. Thereby directing eviction of the defendant, oblique the respondent herein. However, the first appellate court decided the question of the issue pertaining to defaulter in payment of rent against the plaintiff and decided the issue of bona fide requirement in favor of the plaintiff. Be that as it may, the appeal and a revision under section 115 of the code was filed before this court, which was registered and numbered as CRP number 77/2014. This court, by an order dated 3/11/2016, taking into account that the said judgment so rendered by the learned first appellate court was not in accordance with Order 41, Rule 31. Reversed the said judgment and remanded the matter back to the first appellate court for recording a fresh decision of the issues by discussing the evidence available on record and by keeping in mind the principles embodied in Order 41, Rule 31 of the Code. This code further directed the First Appellate Court that taking into account that the suit is of the year 2000, an endeavor should be made to dispose of the suit within a period of 6 months from the date of receipt of the record. It is in pursuance to the said order of remand by this court. This is the impugn order. The impugn judgment and decree was passed on 22/9/2017 by the First Appellate Court. Thereby holding the issue of bona fide requirement as well as the issue of defaulter in payment of rent against the plaintiff. And accordingly dismissed the suit. Being aggrieved, therefore, the instant revision application has been filed under section 115 of the code. I'm coming in 5 minutes. The two primary issues in respect to which arises for consideration before this court is as to whether the petition, whether the respondent herein, who is the defendant, was a defaulter in payment of rent, and as to whether the petitioner herein, who is the plaintiff, had a bona fide requirement for the purpose requirement of the scheduled premises. Let this court first take into account the issue pertaining to default in payment of rent. Yeah, some are very in conflict. Some are very The issue pertaining to the default in payment of rent is issue number 4. The First Appellate Court after taking due notice of the fact that the defendant had claimed to have made the deposit as per the convenience and as per the accepted custom for a period of 2-3 months together. Did not decide as to whether Section 5(4) of the Act of 1972 permits deposit of rent in 2/3 months together in advance. The First Appellate Court went into the question that as there was hostility amongst the plaintiff and the defendant, the offering of rent would have been a mere formality. At this stage, if this court takes note of Section 5, of the Act of 1972, it stipulates the various grounds on which a tenant may be evicted. Section 5(1)(e) stipulates that when the tenant had not paid the rent lawfully due from him in respect of the house within a fortnight of its falling due, would come within the various grounds on which eviction can be sought for. Section 5(4) is a further protection being given to a tenant when the landlord refuses to accept the rent, lawful rent offered by his tenant. And in that case, the tenant may, within a fortnight of it becoming due, deposit in the court the amount of such rent together with the process fee for service of notice upon the landlord. And on receiving such deposit, the court shall cause a notice of the receipt of such deposit to be served upon the landlord. And the amount of deposit may thereafter be withdrawn by the landlord on application made by him to the court in that behalf. It is only when the parameters set out in section 5(4), the conditions as set out in 5(4) is fulfilled, a tenant who had made such deposit shall not be treated as a defaulter under clause E of the proviso to subsection 1 of section 5. In the instant case, admittedly, the tenancy was on the basis of monthly rent. The rent, therefore, had to be paid on monthly basis. It being an admitted case by the defendant that 2-3 months rent was paid in advance would not come within the ambit of section 5(4) for granting the benefit that the defendant was not a defaulter in terms with section 5(1)(e) of the Act of 1972. Now, coming back to the facts of the instant case, it would be seen that the court below, the First Appellate Court, did not take into consideration the said aspect of the matter. And on the other hand, went into only to the aspect that in view of the hostility, the tendering of the rent and the subsequent refusal of the rent by the landlord was a mere formality. The First Appellate Court did not take into consideration that the rent admittedly was paid in 2-3 months together. Which could not have been said to be a lawful rent offered on it becoming due. Under such circumstances, this court is therefore of the opinion that the defendant, as is not saved under section 5(4), would be a defaulter in terms with is not saved under section 5(4). Of the Act of 1972. As the said tendering of rent was not in accordance with the said section, would be a defaulter under section 5(1)(e) of the Act of 1972. Next. The next issue which arises for consideration is as regards bona fide requirement. which was the issue number 5. The first appellate court, while dealing with issue number 5, had taken into consideration the evidence which was tendered to the effect by the plaintiff to the effect that plaintiff number 3 had his business at Delhi, which was shut down on account of various orders passed by the Supreme Court. But on the ground that there was no sufficient materials pleaded that how the suit pleaded. And the plaintiff had failed to show that he had taken steps to set up his business in the tenanted premises once the same is recovered. The issue of default in payment of rent was reversed. The issue of default in payment of rent, default for bona fide requirement of the land of the suit scheduled premises was decided against the plaintiff. At this stage, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Pratap Rai Tawani versus Uttam Chand and another, reported in 2004, 8 SCC 490. Wherein the Supreme Court dealt with the aspect of bona fide requirement and as to how the subsequent events in respect of bona fide requirement is to be taken note of by the court. In a copious detail of the various judgments of the Supreme Court, in a copious detail of various judgments rendered earlier, the Supreme Court in the case of Pratap Rai Tawani Supra had observed that paragraph number 7 to 17 as hereinunder. Subsequent thereto, by another judgment in the case of Syed Nagzi Purushottam and Co. Limited versus Bimal Bhai Prabhulal and others, reported in 2005, 8 SCC 252. The Supreme Court at paragraph number 4, 5, and 6. Observed as hereindunder. In the same judgment, the Supreme Court categorically observed it under 4, 5, and 6. From a perusal of the above quoted paragraphs of the judgment in the case of Syed Naqzi Purushottam Supra, the Supreme Court observed that it is always the prerogative of the landlord that if he requires the premises in question for bona fide use for expansion of his business, there is no ground to say that the landlords are already having their business at Chennai and Hyderabad. Therefore, it is not genuine need. It was observed that it is not the tenant who can dictate the terms of the landlord and advise him that what he should do and what he should not. It was observed that it is always the privilege of the landlord to choose the nature of the business and the place of business. Further to that, taking into account the contextual matrix in the said case, it was further observed that it is not possible for the landlords and their sons to wait till the disposal of the case. They have to do something in life and they cannot wait till the appellant is evicted from a premises in question. It was observed that it is a common experience that the landlord-tenant disputes in our country takes a long time and one cannot wait indefinitely for resolution of the said litigation. If they want to expand their business, then it cannot be said that the need is not bona fide. Further to that, in another judgment of the Supreme Court in the case of Raghunath G. Phalane, dead by LRs versus Chaganlal Sundarji and others, reported in 1999, 8 SCC 1. The Supreme Court at paragraph number 9, 10, and 11 observed what is bona fide requirement. The said paragraphs for its relevance is reproduced hereunder. From the above, it would be therefore seen that for the purpose of bona fide requirement of a landlord, what is required is that it must be something more than a mere desire, but need not certainly be a compelling or an absolute or a dire necessity. A bona fide requirement is something in between a mere desire or wish on one hand and a compelling or dire or absolute necessity on the other. Now, coming to the facts of the involved in the instant case, it would be seen that the plaintiff's case is that the plaintiff was carrying business out there at Delhi, which on account of various orders passed by the Supreme Court, the said business was closed.
If I may pause, Your Lordship. Your Lordship, in the cross-examination, it was admitted by them it was not closed down and it was badly affected. And he has admitted that they have not submitted the order of the Supreme Court by which his business has been affected. It was closed, that was not closed, it was admitted in the first.
Illegally. It further transpires from the analysis of the evidence by the First Appellate Court it was observed that plaintiff that as per the observed that the plaintiff failed to bring cogent evidence to show that as per the direction of the Supreme Court, his shop was closed, for which he suffered loss in the business and wanted to come back to Bongaigaon. The First Appellate Court further observed that except exhibiting some newspapers being exhibit 2 to 8, the plaintiff failed to prove that the fact of closure of his shops on account of the Supreme Court's direction. To show that his business suffered as a consequence of the decision of the Supreme Court. It was further observed that though the plaintiff had averred that he proposed to start the business of trading, but in his cross-examination, the PW3, the plaintiff number 3, disclosed that he had not finalized the items in which the business of trading could be done. Taking into account the same, the First Appellate Court therefore rejected the plea of bona fide requirement. From a perusal of the judgments as quoted here in above, it would show that merely because what business the petitioner, the plaintiff, wishes to start in the scheduled premises once evicted, being not set, being not mentioned in his evidence, cannot be a ground that the plaintiff did not have a bona fide requirement of the suit premises. The plaintiff have averred in his evidence that he wants to come back to Bongaigaon to start a business in the scheduled premises. The pleadings the only requirement which the First Appellate Court ought to have looked into was as to whether the requirement, whether the requirements so made, the requirement of the scheduled premises by the plaintiff was for purposes bona fide. That is something above mere wish, but it need not be a compelling or absolute or dire necessity. This aspect of the matter, however, was not looked into by the First Appellate Court in deciding the issue against the plaintiff. Considering the above, this court, therefore, is of the opinion, taking into account the evidence which have been led by the plaintiff, that the plaintiff had a bona fide requirement of the suit premises. Accordingly, the issue number 5 is also decided in favor of the plaintiff. In view of the above, the plaintiff, therefore, is entitled to eviction of the defendant from the suit premises, from the scheduled premises. How much time?
Lordship, they're in possession since 1965, Your Lordship.
How much? Earlier, I used to give 6 months, but 6 months is too long. Give 2 months. Sitting out there in the pension bench, one gets used. 2 months is too long a time.
Lordship may, as directed in Rashmi Rekha's case, direct me to file an undertaking there. In absence of that undertaking, they may start execution in lines of the judgment of Rashmi Rekha.
That undertaking only at the time of, if you plead that you are going to vacate. Otherwise, why should I?
Since they're occupying since 1965, Your Lordship. So at least
So,
1 year's time, Your Lordship. 1 year's time.
huh?
1 year.
That is too much, my lord. At best, my lord, if they want 6 months.
9 months. 9 months too long. 6 months. 6 months. Taking into consideration that the defendant have been carrying on the business of what business?
Clothes store.
Of clothes since long. Mr. B.J. Mukherjee, the learned counsel appearing for the respondent, defendants, submits that if the defendants are immediately evicted, serious irretrievable injury would be caused, as it would be very difficult to immediately find an alternative location for carrying out its business. Taking into consideration that the defendants have been carrying on their business in the suit premises for more than 5 decades. 5? 4 decades.
65, Your Lordship, admitted.
For 55 years. It would be just and reasonable to grant them 9 months of time to vacate the suit premises, provided they submit an undertaking before the trial court. Trial or executive, or trial court. Within, today is what date?
Is
Fifth.
5th of June.
Within 2023, to the effect that they shall vacate the suit premises within a period of 9 months from the date of the instant judgment, that is on or before 9 months. 9 or 6? 6
6 months.
6 months. 6 months. 9 months. 6 months. On or before, as you all said, January, June, July,
December.
August. No, June,
December
July,
2020.
August, September.
December.
December, on or before 5th of December, 6th of December 2023. Failure to submit the undertaking within the period the plaintiff oblique the petitioner herein shall be entitled to initiate execution application for evicting the defendants.
And the rent shall be paid directly to me, my lord, for these 6 months, my lord.
It is clarified that during this period of 6 months,
Rent is only.
the defendant shall continue to make payment of the amount of rupees
280 only, at that.
280 per month
At that time, my lord.
in the form of compensation to the petitioner, oblique the plaintiff. It is further observed that granting of extension of the period of 6 months subject to filing the undertaking as aforementioned, and the payment of compensation of rupees 280 per month during the period of 6 months shall not create any right or interest in favor of the defendants oblique the appellant of the respondent herein in respect to the scheduled premises. It is also clarified that during this period, the defendant shall remain in possession of the suit premises as the custodian of the plaintiffs and shall not do any act or acts which may affect the right of the plaintiffs over the suit premises in any manner whatsoever. In this aspect of the matter shall also be mentioned in the undertaking so sir to be filed by the plaintiffs, undertaking to be filed by the defendants before the trial courts. Next. The petitioners herein, the plaintiffs herein shall be entitled to the rent for the period of the eviction proceedings, either through adjustment of the rent already deposited in the court or by making an application before the executing court to decide on their entitlement of the rent during the pendency of the eviction proceedings. And the executing court would permit the tenant oblique the respondent herein to controvert the allegation of non-payment of the rent during the pendency of the eviction proceedings, and thereupon they decide in accordance with law. With the above observations, the instant petitions stands allowed. LCR returned.
Item number 8.
Yes,
The petitioner filed the instant revision petition for setting aside and quashing the order that is 7/9/2019 and 18/6/2022.
for what?
Petition number.
What order is being passed here?
My lord, first petition was.
Set aside the order of dismissal in respect of the order dated 7/9 in title suit number Iman and subsequently the order passed in which have been wrongly and illegally by the plaintiff that the plaintiff had no right title interest. Yes, which orders you are referring to? You want the set aside?
Page 37 to 43, my lord.
Huh?
37 to 38 is order annexure 3.
You are challenging 37. What does it say? It is pertinent to mention that they had alleged fraudulent in the respect of the said deed and as such claim can only be appreciated in terms of evidence or demand, and the petition as such cannot be entertained at this stage. Seeking the suit and because the plaintiffs have fraudulently filed the suit which was alleged to have been executed. Plaintiff claimed that they had not Yes. You are challenging the order at page 37.
37 and 39 to 43.
39 to?
43.
What is this 39?
Annexure 4, page 39 to 43 is subsequent order dated 18/6/2022, madam. without considering the first application and imposing the cost of rupees 3,000 and prayer of the defendants are rejected. Against of that petition order, my lord, file the another petition, my lord, on my lord, 18/6/2022, without going to the merit of the case, my lord, again impose the cost of rupees 2,000 and rejected the prayer. And this has this instant revision petition for paying for setting aside the order dated transfer 7/9/2019 and 18/20.
So what is wrong?
Petitioners, my lord, plaintiffs filed this title suit, my lord, on the based on the false and fraudulent deed
So-
of agreement, my lord.
The trial court will look into it.
That's all right, my lord.
Then-
We have filed this petition, my lord,
Cost how much?
3,000, my lord.
No, cost upon you now. How much?
3,000.
No, that was, he has only, the trial court was wrong in imposing you cost of 3,000. How much upon you, the lawyer and the client? 50/50? You pay 50,000 and the client also pay 50,000? What do you say? 2017 suit, you have stayed it? Is there a stay?
I am the defendant, my lord.
Understood,
I am the shareholder.
understood, very well.
With the- with
The
the-
suit has not been stayed. You have filed your evidence, prove your case, or let the plaintiff prove his case. You are saying that the document is false. Are you not supposed to prove it before in the court of law?
my lord.
Then what remains in the suit and these applications?
And my lord, the defendants filed this petition, my lord, for setting for the title suit, my lord. But and to claim the maintainability of the issue, my lord.
You want the maintainability of the issue,
Issue, my lord.
issue frame?
Yes, Lordship.
Are these issues framed out there?
Draft issues are not submitted like that, Lordship.
Okay.
Whatever has been.
You do
presented
one
to-
thing.
Yes.
My lord.
Is it a part of your pleadings in the defendant, as a defendant?
Defendant, my lord.
Have you raised these issues in your written statement?
My lord, my lord.
You have done it.
That is-
So then if you want, you can submit. What is the stage of the proceedings?
The evidence is going on, Lordship. The PW1 has been submitted.
Okay, no problem. Evidence can, the issue can be framed at any point of time.
Exactly, Lordship. And-
So
and
this-
these applications
You
are-
want for framing any additional issues, you do it. I have, you are appearing in a civil court, you have the CPC with you?
My lord.
Yeah. Take it out.
Page number 19.
No, no,
20,
no
my lord.
page
Yeah,
when
my lord.
nothing is
Yes,
required.
my lord.
Take out the CPC. See, order 14, rule 5. Your name?
B. Islam, my lord.
B. Islam.
My lord.
Heard Mr. B. Islam, the learned counsel for the petitioner. Mr. SP Chaudhary appears for?
For all the respondents, Lordship.
Appears for all the respondents. The instant application under section,
No mention.
here also,
Yes. The Lordship
115. Under section 115 of the Code of Civil Procedure 1908. Have been filed for Code of Civil Procedure 1908 brackets code. Have been filed challenging the orders dated 7/9/2019 as well as 18/6/2022 passed by the trial court, whereby the applications filed by the petitioner herein, who is the defendant in title suit number 25/2017, were rejected with cost. From a perusal of the orders dated, impugn orders dated 18/6/2022, as well as the order dated, from a perusal of the order dated 7/9/2019, as well as the order dated 18/6/2022, passed by the trial court, it reveals that the said orders, that the applications on the basis of which the said orders were passed where on the basis where the defendant sought for dismissal of the suit on the ground that the document on the basis of which the plaintiff have instituted the suit is a fraudulent document. These aspects of the matter, the question as to whether the document on the basis of which the plaintiff has instituted the suit is a fraudulent document or not can only be decided at the trial of the suit. Accordingly, the trial court rightly had rejected the applications by the orders dated 7/9/2019 and 18/6/2022. Accordingly, this court therefore finds no ground to interfere with the orders dated 7/9/2019 and 18/6/2022, for which the petition stands dismissed. However, this court finds it relevant to observe that the petitioner, if the petitioner oblique the defendant, if so advised, may file appropriate application for framing of additional issues if the issues have not yet been framed. If the issues pertaining to the pleadings have not been framed by the trial court.
9.
Yes, Binta Bhagavati.
First appeal.
Okay. First appeal for what?
First appeal,
Right title interest.
title interest.
What has been declared?
It doesn't, there is just. no
The
contested
plaintiff
very
along with the dismissed as the defendant has not contested the suit. There is no
Because this space by
ex parte
Ex parte
dismissal.
yes, Lordship.
So your case is so bad.
No, Lordship. In fact, that my document could not be understood by the
Appeal
others as well.
admitted, call for the records. Heard Mr. Ipswich. And what is this IA for?
I have for injunction that notice, even not notice issue, he may not.
For what?
At the time, during the pendency of the appeal, he should not. Just for sale, etc., etc.
They cannot heard Mr. B.K. Bhagavati issue notice, making it returnable 4 weeks. Hey, to Agotu. Huh? Appeal, yeah. Yeah, admit, call for the records, issue notice, making it returnable by 4 weeks. I issue notice.
Your Lordship, I am appealing for deputy commissioner. Respondent number
So and so appears for the
K. Pukar. Respondent number 1.
Number 10.
yes. What is your case about? Section 23, appeal. Why the railways are not here? They don't like it? Or they don't want, have you served a copy upon them?
No, my lord, after issuing notice, my lord,
Hmm?
I have taken this picture. After issuing notice, my lord, by this honorable, I
No, are the railways not admitted appearing? Why haven't you served a copy on the Union of India? Matter of the Chalo. What is your name?
just Islam, my lord.
S. Islam, the learned counsel for the appellant. Appeal admitted, call for the record, issue notice upon the respondent number, upon the respondent. Steps by way of registered as usual within 6 weeks.
11.
This is a miscellaneous part. Is just been filed by the Mr. Commissioner. Acha.
Railway,
No, lordship. The employees commissioner.
employees compensation. Yes, what is your ground? We have to frame questions of law.
Yes, lordship, that's a synopsis I have written. But they are also
Whether in the
the
given
memo
facts where the owner of the vehicle had not deduced any evidence to prove that driving license was not invalid, as alleged, the owner of the vehicle can be exonerated of the liability under the policy. Whether there has any evidence that the vehicle was carrying excess person, then the authorized to enter the insurance can be held. Number 2 is a question of fact.
This is
Can it be a question of law?
Yes, lordship.
No?
Lordship, yes, because in.
Whether
similar-
there
in
is, there
similar
was
situation,
evidence that the vehicle was carrying excess persons than the year. Whether there is evidence or not, that's a question of fact.
We had given evidence to that effect.
So then it will be whether then it will be a case of perversity. But that's not the question.
Lordship, what has happened in
Whether
this case, I'm
non-consideration
entitled
of
to
that-
Right of recovery, Lord. In such cases, I am entitled to right of recovery.
Definitely, but where is your, but that is not a question of law.
Lordship, Lordship, this jurisdictional fact was not properly considered. It's
Jurisdictional fact was
not-
not
It was
proper.
carrying persons. It
If
was
a
taking more
jurisdic,
persons.
no, Mr. Goswami, if the jurisdictional fact is not considered, it may be a case of wrong exercise of a jurisdiction. But can it be a case of a question of law?
It can be a question of.
How? Let us see where there was evidence that the vehicle was carrying so and so, then the authorized carrying capacity. The appellant as insurer can be held liable for liability without giving the right to the insurer to recover the same from the owner of the vehicle. Let us see what is this case.
But there's another real Lordship, that first here, the driver was not made even a party Lordship. And we had alleged that driver did not have a proper license.
Let us see your statement, the written statement. Have you stated about the driver's license?
Lordship, I just also have a copy of the Lordship, owner's written statement. It is settled position of law, Lordship, that.
But you have never raised. Have you raised anything?
I have listed in my evidence, Lordship. It came to our knowledge later.
When?
Because drivers, Lordship, just one,
Then how can he?
Driver's name is not anywhere in the. petition.
No, but
The owner of
here,
the- owner
but
of
Mr.
the-
Goswami, kindly come to this particular paragraph number 17 of the judgment.
Yes, Lord.
Here say he had a valid driving license.
Lordship, that is not the fact, Lord.
And it is there.
Lordship, I have a copy of his written statement.
Whose written
The
statement?
owner's statement. He had filed only written statement thereafter he did not participate in it. Lordship, in this, he was required, Lordship, I'm reading out from a three-judge bench. This is what is required under the law. Without disclosing the name of the driver in the written statement or producing any evidence to substantiate the fact that copy of the driving license produced in support was of a person who in fact was authorized to drive the driving vehicle, offending vehicle at the relevant time, the owner of the vehicle cannot be said to have extricated himself from his liability. Insurance company would become liable only after such foundational facts are pleaded and proved by the owner of the offending vehicle.
This is a case pertaining to.
According to MSc, Lordship.
So MSc, how is it applicable here?
Lordship, position of law would be the
MSc
same.
will appeal will admit it.
Responsibility of the owner, Lordship, would be remain the same. If the claimant's position that changes.
Understood, but here we are to do it on the basis of a substantial question of law.
Such is the question, that's what I'm saying, Lordship.
Now, if that is not your pleaded case in your written statement,
In the affidavit, Lordship, I have it.
Where?
Because this information came a little later.
now,
In
when?
affidavit, para number 5 of the affidavit.
Here,
Yes, Lordship.
not there.
There.
Now, did you raise this issue that he didn't have a license?
Yes, Lordship.
Where?
In the affidavit.
Affidavit means evidence,
Evidence. The company had given evidence to that effect.
and he
That
was a
the
cross-examined.
Driving license number we could only get only from the police report, that form 54. The claimant did not bring the driver into it. The owner did not even disclose the name of the driver. Did not even in the written statement. I can read out a copy of the written statement. Lord. I have a copy of his written statement here. He did
Show me
not-
your written statement.
My written statement, Lordship, it is not there. I have always said. I have admitted, Lordship, it was not raised because they did not know.
You must be having an affidavit.
Yes, I am happy.
Show me that. And your cross-examination.
Lordship, entire records I have given.
Then,
I thought this would be enough to get the.
No,
get the-
no,
then we'll
no.
Get the LCR.
no,
and-
if you are saying that this court should admit just like a normal appeal, then don't you think that it would not be proper? The driving license number mentioned as 5-point form number, yeah, valid up to so and so issued by Iman. But after verification, it is found that the state driving license is not correct as per the office record of the DPO Silchar. Therefore, the owner of the alleged accident had violated the terms of truant. Now, what is your basis of saying that it is not
He got
valid?
Only from a FIR, Lordship.
Huh?
From a
No,
accident
no.
information report.
What you are stating
Because
out
no
here,
one- The claimant disclosed.
then
that
how
he
can
not
you?
disclosing the driver.
This can't be the round of this.
The owner does not say anything about the driver or the license.
Accident
The
report.
latest is, Lordship, from the accidental information report, AIR. That was somehow.
Your basic case is that he does not come within the
the
ambit.
right of recovery, Lordship. That if I don't file an appeal here, how will I get it? That was there. The vehicle was carrying access, and we have given evidence to that. Police report, and this is also their admitted cases that so many persons died. They filed it in their complaint. So that is one position that remains admitted, that the number of persons which were carrying was more than the authorized capacity. That is evident from their written claim petition and also other. So at least for that part, Lordship, right of recovery. If on the ground of excess carriage of
On the ground of,
excess carriage of pests, that I have to.
that is well settled by a division bench.
On which part?
Page number 12 of your appeal. There is a division bench judgment in National Insurance Company by the Lilu Rani Mujumdar.
That there are also other evidence, Lordship. Perhaps this permit, Lordship,
The decision of the Supreme Court Lordship, this is where Amrit Pal Singh versus Tata AIG.
So have you paid the money? No, Mr. Goswami, have you paid the money?
No, not required, Lordship. Not required, Lordship.
Not required for what?
Like earlier, Lordship, the position is there, WC appeal, EC appeals cannot, are not admitted until and unless that deposit receipt is shown to the court. That is enclosed with the E. There is, after that, there has been a change in the year, Lordship, there is judgment in the Supreme Court in a case where these WC cases are admitted without deposit of whatever. I thought that is the practice for last about 10 years.
But there's the stay without there's a stay of
In the
the,
time of stay, Lordship, we are asked to deposit whatever the court feels.
you deposit 100%. Your only question is right to recovery.
Yes.
So we'll admit it.
No,
but
that is
you-
the only, I have got the,
but
that's my,
deposit 100%, because you have no problem in getting that money. Your only problem is not to, you are not in a position to recover.
that is also my ground, Lordship.
Hello.
Substantial question over in the.
Or
without
Mr. R. Goswami, the learned counsel appearing on behalf of the appellant. The instant appeal is admitted on the following substantial question of law. Page 7 of the essay, Dita Didi. Issue notice, making it returnable by 6 weeks, steps within 3 days. IA conclude. What is this IA for?
I have first stay, Lord.
IA Kondibo, IA so and so. This I heard Mr. R. Goswami, the learned counsel, appearing on behalf of the appellant. This is an application under Order 41, Rule 5 of the Code of Civil Procedure 1908 for short the court for stay of the operation of the judgment and order dated 20/2/2023 passed by the Learned Commissioner for Employees Compensation, Kachar, in EC case number 24/2016. After hearing the matter and taking into account that it is only the only case of the petition, the appellant, is that the right of recovery has not been given to the appellant insurance company. The insurance company is aggrieved. This court finds no reason to withhold the payment, withhold the awarded sum to the claimant, oblique the respondent numbers 1 and 2. Accordingly, this court therefore disposes of this interlocutory application by directing the appellant insurance company to deposit the entire amount within a period of how much? 6 weeks? 6 weeks from the date of the instant order. The appellant, the claimant, and the opposite party number 1 and 2, where the claimants shall be entitled to withdraw the said application by filing appropriate application before the registry, and the registry shall, upon necessary verifications, release the said amount to the respondent number, opposite party number 1 and 2. I stands disposed. What is this MAFA? Oh, nothing. I can wait.
Well,
Yes.
Not appeal for enhancement, my lord.
Enhancement?
My lord.
You are?
Lordship, I am appearing for respondent number 2 on behalf of my senior RC Pal Insurance Company. Lordship, in the last instance, the delay was condoned, but till today they have not served us copy of memo. I'll serve copy, my lord.
You are enhancement.
Enhancement, my lord.
heard Mr. So-and-so, the learned counsel. What is this enhancement business? Why are you asking for enhancement?
But that case, my lord, award was, my lord, amounting to rupees 1,20,000 only. Claim was for 8 lakhs.
Award is? Why?
1,20,000.
No fault liability 50,000. Huh? Loss of consortium 40,000. Loss of estate. Why not a single penny on the other aspect?
My lord, that is why, my lord, I am before your lord.
No, why? Is it mentioned anywhere? Failed to prove that his deceased brother was earning member of the family, although the claimant had mentioned in his petition. But if he is not earning, then also 4,500 should have been minimum given
My lord.
along with the age.
My lord.
Or Mr. Ayali,
TK Bhuya, my lord.
where are you?
Really, my lord, last 3 months he is under treatment at Kolkata, my lord. I am requested to represent him.
What about Mr. M. Khatun?
He is wife, my lord, for years.
D. Deori?
He has left his chamber, my
Fantastic. Your name?
TK Bhuya, my lord.
So and so, the learned counsel appearing on behalf of the appellant. To stop. Appeal admitted, call for the records. Mr.
A.R. Das, on behalf of my senior RC Paul.
Or?
On behalf of my senior RC Paul.
None issue notice making it returnable on 6 weeks.
Deep level.
No, I am not in recording anybody of you. You'll issue notice making it returnable in 6 weeks.
Item 14 for hearing under order 41 rule 2.
What? SAO?
My lord.
What is this case? SAO?
SAO, my lord.
Against remand?
No, not against remand, my lord. It's against if your my lord takes up CPC.
Where is the impugn order?
Impugn order is at annexure 10, page 67. My right to substitute myself has been rejected. May I read the order?
Legal. How much delay?
736 days delay.
Very well, rightly done. Why?
Because we, the appellants, were not aware that that our predecessor in interest, who happens to be a father,
The father had expired.
father expired.
The appellants were not aware.
Not aware at all. Only when the lawyer sent them a letter in the name of the predecessor in interest, then only they came to know that there was a suit, and thereafter an appeal was preferred by the predecessor in interest. Therefore, the delay.
What is this case which was there in appeal?
Thus, the respondent before our lordship had filed a suit against the predecessor in interest of the appellants.
You? Against your father?
Against my predecessor in interest, against my father.
Regarding what suit?
Regarding declaration of right capital interest, cancellation of the sale deed, and for permanent injunction.
For what? Land?
Land.
Which land?
Land is.
Where you stay?
No, I don't stay there. I don't stay there. Stay there. We stay there. Yes.
Now what happened?
Now,
did you the other side? You were the defendant.
I was the defendant. The defendant.
The suit was The suit was allowed.
The predecessor interest filed his written statement, but because it was filed beyond 90
The
days,
suit was allowed.
the suit was allowed.
Decreed.
Decreed.
So the suit was decreed.
Decreed. Thereafter,
There
my
you filed an
predecessor-
appeal.
My predecessor filed.
What was the decree passed in that suit?
Decree for declaring right title interest and cancellation of the sale deeds
And
and for permanent injunction.
permanent injunction for what?
And for permanent. The judgment is here.
No, there is no eviction.
Yes, recovery of possession. Recovery of possession.
Okay.
It was there.
ठीक. Then what happened? You filed an appeal.
I filed an appeal.
You got a stay.
I got to stay.
100%.
Yes. First appeal normally stays. I'm not aware of that. But thereafter, my
No,
predecessor-
you must have got a stay.
You must have got a stay. Must have, but I'm not.
Then somebody died. What happened to the thing? Did they take steps for recovery? Eviction?
No. Till now, they have not filed any execution case.
Till then also they didn't file any.
They have not filed. Now also they haven't filed. Therefore, I haven't filed any stay petition also before this honorable court. And in this case also, there was a delay of 44 days, my lord, and that has been duly condoned by this honorable court. But notices were duly served to the respondent. They did not agree. In this case as well.
Now, why it took 736 days? You didn't know that there was a litigation on the paper in respect to the matter? How young are you?
We are all majors at this point of time. Above 18 years.
Then?
Around 35, 30 years old. Yes. But we didn't have any knowledge about it.
That there was a case?
That there was a case. We didn't have knowledge. Our father had defended the case, but we have no knowledge. Only when the lawyer sent a letter in the name of our father. Then
After 2 years?
After 2 years.
For what?
That there was no contact between the lawyer and my father. So the lawyer wrote to my father. And in the meantime, my father had already passed away. I went to the lawyer's chamber.
Where is the letter?
And the letter is not enclosed here.
So isn't that your letter the most important
Yes,
document?
that is the very important document, but it has not been.
But without the
enclosed.
letter, why should I consider it?
Otherwise,
Because the letter gives you the reason to
Yes,
know.
absolutely.
So you have known only on the basis of the letter. Let us see what is your statement in your application.
The application before the court below, my lord.
Yes.
That is at annexure 7. Annexure 8. Annexure 8, page 59.
Annexure 4?
Annexure 8, page 59 is
Annexure
my
4,
application for condonation of delay. Before the
Unless
court
after
below.
receiving the letter, like to state that Vijay Roy and the daughter visited senior advocate SP Roy chamber on 16th of day of September 2018 after receiving the letter from the court. Who is Ashok Kumar Roy?
Ashok Kumar Roy was the plaintiff.
Who is he?
Ashok Kumar, Anandi Kumar, Ashok Kumar Roy is the plaintiff.
How are you both connected?
We are connected. Connected. Relation. There are no relation. Actually, the fact of the case is that the
Because you are also right.
Sorry,
You are also right.
I am also right. I am also.
How are you connected?
No, we are not related.
Then
The grandmother of Ashok Kumar Roy, grandmother of the respondent plaintiff, she gave power of attorney to defendant number 2 and 3, who are not.
Ashok Kumar Roy and your father stayed in the same locality at Torun Nagar.
Locality is same. Locality is same. Torun Nagar.
Then
The grandmother of plaintiff.
why did it take 2 dates for Mr. Dinesh Agarwal to file this application?
The record was not with him. The record had to be taken from the other lawyer's chamber. That has
But
been
how much
stated.
date you going to take then? After 2 months, you know there is already a delay. How do you explain that?
Yes.
Then
But the record was only released by the other lawyer on the day, 1 day before the date of filing these petitions. Therefore, it could not be filed. That is the reason.
Hello. Your name? Mr. S. Burwa, the legal counsel appearing on behalf of the appellant. Appeal is admitted. Call for the records. Issue notice upon the respondent. Turnable by 6 weeks. Weeks time was granted to rectify. Who has granted?
My lord, from the concerned section, my lord, I could learn that the defective cases were listed before the
Lavazima court
honorable
granted.
Honorable court, my lord, not Lavazima court. And honorable court granted 3 weeks time to rectify. But I could not rectify the defect. Therefore, subsequently, court was listed before the Lavazima court. And Lavazima court asked me that the appeal was dismissed, you may file a press.
But it was listed before the court.
Earlier, defective cases were listed.
Your lordship will recollect in 2018 lordship, almost all the defective cases were listed lordship, and all the records were put up before the honorable court. And in that case, order was passed.
Why don't you, Mr. Saikya, why don't you file an application for restoration of that?
My lord, I approached my lord before the.
Why don't you file an application for restoration? Let it come before the court.
That is the proper.
Why you are asking all these things?
My lord, I approached the Lavazima court, my lord.
Mr. Counsel,
My lord.
if you want this court to be the Lavazima court, I can go there and sit out there.
No.
Then why I am asking you, why don't you file an application for restoration? In that case, we can take it up. That application has to be listed before this court.
Yes.
Then we can take it up. That is the way out. If this appeal out here, you file that application, and then we'll look into it. You see, this court, the court directed you to complete within 3 weeks. Fantastic. After these 3 weeks, you have not done it. It's a lawyer's mistake. Can that person be penalized? We may impose a cost upon you of 50,000, 1 lakh. That is a different thing. But then also you can't impose the appellant. Isn't it? So file an application. We'll see later on.
Lord, what happened, my lord? All the
I understand
elements-
why you are not
papers
understanding
given
why the records are still there. In
Record, my
that
lord.
IA, you file an IA.
Record is in my hand, my lord. It
Which
was
record
That original record.
is with you?
Yes, my lord. Case record. It was returned back to me. Defective file returned to the concerned advocate. That is why, my lord,
So this was done under Order 41, Rule 3. I hope. See the provision. If it is done under Order 41, Rule 3, what is your course of action? Read it.
where the memorandum of appeal is not drawn up in the manner herein before prescribed, it may be rejected or be returned to the appellant for the purpose of being amended within a time to be fixed by the court or be amended then and there. Where the court rejects any memorandum, it shall record the reasons for such rejection. Where the memorandum of appeal is amended, the judge or such officer as he appoints in this behalf shall sign or initial the amendment.
Now you know what is to be done. I hope you don't expect this court to further advise you. Do the needful. It's the matter immediately after the summer vacations. You see, it is the court who has to do it, not the Lozima court. He has to have the signature of the judge. Dismiss.
My lord, by order 17.5, as report reveals, my lord, an observation was made that the case was dismissed without any further reference of the.
Not necessary. Whatever order cannot supersede what is the requirement of.
Oh, like,
21.
File a review or do whatever you like.
The title should have been executed by the petitioner.
Why is this FAO alive since 2018?
My lord,
What do you
small
want?
mistake from my part, my lord. At the time of my lord filing evidence on affidavit, on that day the learned counsel children sustained some medical problem.
What is the order?
My lord, order in page 70, my lord. Start from
70?
68, my lord.
68. So and so in Iman,
Property part in page
recalling
70.
and setting aside the order dated Iman, passed in Iman, whereby the court dismissed the suit for non-filing of evidence on affidavit of so and so. Stated entirely that due to certain new developments in so and so on Iman, the plaintiff did not file the evidence on affidavit and time by the
Round of rejection, page 70.
How are you maintaining an FAO?
My lord, this is also one question, my lord. Thing is that, my lord, otherwise, my lord, that my petition has been rejected, order 9 rule 13, my lord, basically.
What is this order 9 rule
My
13?
lord, the reason behind is that, my lord, that rejection was done, this suit was dismissed, my lord.
Why, how, your plaint was, your suit was dismissed on the ground that you did not tender evidence.
My lord,
Then how are you maintaining FAO?
yes, my lord, revision is to be there, my lord.
Then, and not only that, means this order has to be challenged in that manner.
My lord, only one thing is that, my lord,
We can't entertain this, neither we can convert it.
the justice you want, my lord, that one mistake, my lord, is there, no doubt, my lord, from our part. Lordship restore then.
One mistake,
My lord, because on that day we have failed to submit the evidence on affidavit. No doubt, my lord, we have.
not once. There are 9
Yes,
dates.
yes, my lord. There
Then?
are also some, my lord, dates were there.
Cost 1 lakh.
My lord, minimum, my lord, is a cultivator, my lord.
So upon you,
Not me, can't.
you pay.
My lord,
You are rich, you pay.
my lord,
Then only it was commensurate. No, no, no.
minimum, my lord.
What is this? There is a condonation of delay
My
also.
lord, my lord, there is only one.
Delay condone.
Yes, my lord. One day, my lord.
Huh?
One day delay is here.
Delay is not condone. One day.
Well.
Chalo. We condone and dismiss the appeal. So heard Mr. S. Samaria, the learned counsel, appearing on behalf of the
On
applicant.
that day, I will come with the counsel, my lord, consult with my client, my lord, whether how much
What?
he can pay, my lord, about that. My lord.
No, no. Heard Mr. S. Samaria, the learned counsel for the applicant. The instant application has been filed for condoning the delay of 1 day in filing the accompanying appeal. Taking into account the ground mentioned and that there is only 1 day delay this court. You are there?
Oh, yes, yes, I'm for respondent number 1 and 4.
Okay, so and so appears for respondent number 1 and 2. So taking into
1 and
account the
4.
ground mentioned therein, this court condones the delay of filing the appeal, condones the delay of 1 day in filing the appeal. FAO. Heard Mr. S. Samaria, the learned counsel, appearing on behalf of the applicant,
Lordship, may I interpret, lordship, I may be allowed to withdraw.
appellant. Huh?
I may be allowed to withdraw with the liberty to file, my lord, the proper.
That is what I was
My lord,
passing also.
my lord. That liberty may file. Otherwise, right will go, my lord.
So and so. Mr. Your name?
Yes, my lord, my name is A. Chaudhary.
A. Chaudhary appears for a respond number
1 and 4.
1 and 4. Pusto. The instant appeal have been filed challenging an order dated 6/6/2018, whereby the petitioner's evidence, the appellant's evidence, the appellant who was the plaintiff in the title suit number 457/2012, his evidence was closed on the ground of not filing the evidence within the period in terms with Order 17, Rule 1 of the Code of Civil Procedure. The 17, Rule 1. Order 17, Rule 2 of the Code of Civil Procedure. Taking into account that the said order is not appealable, the instant appeal is not maintainable. Accordingly, the learned counsel appearing on behalf of the appellant submits that he may be permitted to withdraw the instant appeal. He however submits that as it was the mistake on the part of the lawyer which had resulted in the advice for filing the appeal, the appellant should not be penalized for the same. And accordingly, the period during which the appeal was pending before this court, from the date of filing the appeal which has been pending before this court, should be excluded while computing the limitation, should be excluded. Taking into account the said submission, this court permits the petitioner appellant to withdraw the instant appeal However, granting him the liberty to approach the appropriate to approach and liberty as available in the law. The period during which the instant proceedings have been pending, that is from 6th of September 2018 till the date of the instant till today shall be excluded while computing the period of limitation.
All right.
Twenty-two.
My lord, it has come up for order, my lord. As per
Mr. Borua. Order, no order doesn't have any value of this court. This court takes up every day as the last date is the first date. Tell me, what is your case?
Here is a office note dated 1st of June 20.
What are you challenging? RFA,
Yes, ma'am.
service,
Service is, my lord, on
is
first.
there a delay?
No, my lord. Actually, it is already admitted, my lord.
Okay, appeal has been admitted. Records,
Record has come, my lord.
Okay.
Maybe fixed for hearing.
appeal having been admitted and records have been received. The appeal, it appears that the appeal has been admitted and the records have been received. Leaves the matter for hearing in its usual course.
23.
Yes, Mr. Sansidi.
May I please, Your Lord? Well, here only one question arose, my lord. Whether the plaintiff can be added as a defendant, can be transposed as a defendant. Here in this case, my lord.
What are you challenging?
I
By the impugn order
Yes.
dated so and so, passed in so and so, by which the plaintiff number 2 and 3 were transposed as defendant in the suit and allowed to file written statement, should not be set aside. Yes, who are you?
I am the, my lord, plaintiff.
You are the plaintiff.
Plaintiff. And the principal respondent number 1 and 2 were also the plaintiff.
2 and 3.
Principal respondent number 1 and 2.
No, 2 and 3.
Yes, my lord. Yes, my lord. They were the
2 and
principal,
3 were made defendants.
Yes, my lord. They, when the judgment has to be passed, just one day before, they have filed an application that their name should be struck off from the claim. They may be added as a defendant and allow them to file written statement.
Allowed them to file the written statement.
Accordingly, their name has been struck off. For that, I am not agreed. I am not challenging that part. Their name may be struck off. I am challenging the second part, that how they have been transposed as a defendant and allowed to file written statement. So, being agreed by that order.
So you say that order 23 rule 1A
1A.
would only have applied if he was a defendant, so he wants to transpose himself to the appellant
That is,
or the plaintiff, but that is not so. Yes.
Hello.
What is this thing? Yes, they want to get out, they want to impede, they have to file an application under order 1 rule 10. They do so. Isn't the plaintiff the dominus litis?
My lord. I
You file an application that you want to get out, there's no quarrel, that you can very well do so. Order 23 rule 1, you can very well. You want to do that, you file an application, matter ends. Why should we go? You want to be a party, file an application in that suit and then you will be given the permission to file the written statement. If not,
My lord, we have filed the petition under order 1 rule 10(2).
oh, did you file that?
Yes.
Oh, then what is your
That
problem?
is the,
they have filed the application
Oh,
under order 1 rule 10(2).
it is there.
Taking out their name. and
So he
put
wants
them-
to strike off their names from there and
to
become there.
them as a, to add them as a defendant and to allow them to file written statement. That application is there, my lord. But my submission to Petitioner Honorable Court, that Petitioner Honorable Court already pointed out that under order 23 rule 1, only the
No, but their application under order 1 rule 10(2) is there.
Rule 10(2). But what happens here in this case, my lord, I have not filed any case against them. Rather, they were the plaintiff. We jointly filed the suit for declaration of a right title in interest in respect of the property which has been sold by the property defendant number 1, 2 to some other person, my lord. We have challenged, and we have also challenged for.
But Mr. Sansidi, it is well settled that a person concerned, if he does not want to continue with as a plaintiff, he can very well withdraw. And that problem you don't have.
I do not.
Your problem is that why he should be made defendant number 7 and 8. The court, did the court take into consideration order 1, rule 10 and pass the order? Let us see the order.
Order, my lord. That is at page 42, my lord. Parties are represented, heard both sides on petition number so and so, and the prayer is allowed in the interest.
Did you file an objection to the order 1, rule 10 too?
I have filed the objection.
Why did you object?
I objected, my lord, that you have claimed together for cancellation of sale deed. If they do not want to challenge the sale deed, their name is struck out. But why my rights should be affected? Because I did not claim any relief against them, my lord. If my suit is dismissed, they will not suffer any. If my suit is decreed, they will get nothing, my lord.
Okay.
Why they want to make themselves as a defendant? They should explain, my lord, why they want to. Because they did not, now they have relinquished their right against the defendant.
Chalo. Heard Mr. R.C. Tripsiti, the learned counsel appearing on behalf of the petitioner. Mr.
Dean.
So and so appears on behalf of the respondent numbers
1 and 2.
1 and 2. Dinandi appears on behalf of the respondent number 1 and 2.
I'm appearing.
The instant application has been filed. You are appearing for?
5, 6, 7, 8.
Mr. K.K. Gupta, K.L. Gupta appears for respondent number 5, 6, 7, 8. The instant application has been filed challenging the order dated 8/3/2019, whereby the court of the civil judge, learned court of the civil judge, Kamrup Metro, Guwahati, had struck off the name of the plaintiff number 2 and 3 and transposed the said plaintiffs as defendants to the suit to avoid multiplicity of proceedings. First, it appears from the records that the suit being titled suit number 128/2010 was filed by 6 plaintiffs. Seeking declaration of their right, title, and interest in respect to the land described in the schedule to the plaintiff, semicolon, for cancellation of certain sale deeds, for issue of precept, as well as for permanent injunction. In the said suit, the plaintiff number 1 and 2 filed an application under order 1, rule 10(2).
2 and 3,
My lord, 2 and 3.
2 and 2.
Or 2 and 3.
It is.
But there is no.
Filed an application under order 1, rule 10(2) of the Code of Civil Procedure, read with section 151. Praying inter alia that their names should be struck off as plaintiff number 2 and 3 and to add them as defendants thereto and allow them to file written statement to contest the suit. To the said application, the plaintiff, the remaining plaintiffs, that is the plaintiff numbers 1, 4, 5, and 6 submitted an objection. The learned trial court, by the order dated 8/3/2019, permitted the withdrawal of the plaintiff number 2 and 3 from the suit as plaintiff, and transposed the said plaintiff as defendants to do complete on the ground of doing complete justice and to avoid multiplicity of proceedings. It is this order which have been challenged in the instant proceedings. I've heard the learned counsels for the parties and perused the materials on record. A perusal of Order 23, Rule 1 of the Code of Civil Procedure 1908, for short, the code, stipulate Order 23, Rule 1(1) stipulates that after the institution of the suit, the plaintiff may, as against all or any of the defendants, abandon his suit or abandon a part of his claim. Taking into account the said provision, the plaintiff number 2 and 3 could have at any stage of the suit abandoned their suit and abandoned their part of the claim. And the same had been done as could be seen from a perusal of the application so filed by the plaintiff number 2 and 3. The provisions of Order 23, Rule 1(a) would only apply in the circumstance when a suit is withdrawn and abandoned by the plaintiff under Rule 1, and the defendant applies to be transposed as the plaintiff under Rule 10 of Order 1. And it is under such circumstances that the court can allow such transposition, subject to the applicant have a substantial question to be decided as against any of the other defendants. However, in the instant case, the plaintiff number 2 and 3, though sought for the withdrawal of their claim as against the defendants, but at the same breath sought for transposition as the defendant. This transposition as a defendant has to be taken into account, applying the law as applicable under Order 1, Rule 10(2) of the code. And more particularly keeping in mind that the plaintiff is a dominus litis. However, if the plaintiff number 2 and 3 upon withdrawal has a direct, has an interest in the subject matter of the suit, has a substantial interest in the subject matter of the suit. The said plaintiff number 2 and 3 in the instant case could have filed, could have been joined as a defendant, but subject to reasons to be recorded as to why the same plaintiffs have to be joined as defendants. In the instant case, it would be seen that in spite of the specific objection being raised by the plaintiff numbers 1, 4, 5, and 6, the learned trial court did not deal with the said objection. And on a misconceived notion applied the principle of Order 23, Rule 1A of the court, for which the order dated 8/3/2019, insofar as transposing the petition, the plaintiff number 2 and 3 as defendant in the suit, is set aside. This court also finds it relevant to take note of that there is this application under Order 1, Rule 10, filed by the plaintiff number 2 and 3, which also requires to be educated in the manner as laid down under Order, in the manner as the law laid down in Order 1, Rule 10. This court therefore disposes of the instant application, directing the court of the civil judge number 6, learned court of the civil judge number 3, Kamrup Metro at Guwahati, to dispose of the application under Order 1, Rule 10(2) by taking into account as to whether the plaintiff number 2 and 3, by taking into account the plaintiff number 2 and 3 as applicants of an application under Order 1, Rule 10(2), and then applying the law as required. By applying the law, consider and decide as to whether that plaintiff number 2 and 3 would be entitled to be defendants in the suit. With the above, the instant petition stands disposed.
My lord, a date may be fixed for appearance of the parties.
Huh?
A date may be fixed, my lord. for
Yes,
appearance.
is there any stay?
There was a stay order, my lord.
So taking into account that the instant petition has been disposed of. Now, taking into account that by the order dated 8/5/2019, the further proceedings entitled suit number 128/2010 has been stayed. This court, in view of the disposal of the instant petition and taking into account that the respondents are the parties are duly represented, directs the parties to appear before the trial court on summer holidays, 6th of July.
Oh, yes.
Deeply oppressed. For respondents, lordship, they have been implicated as a party in this suit. Because this suit in between the appellant and respondents got the decree for specific performance against the appellant.
The suit for specific performance.
Specific performance of contract that was instituted by the respondent, and suit has been decreed.
You got a stay.
Lordship.
You got a stay.
Lordship admitted.
The office note dated 1/6/2023 shows that the service upon the respondent as well as the performing respondents have not been complete. The appellant herein is directed to take fresh steps upon the respondent as well as the performing respondents within 7 days from today by way of registered post. List the matter after completion of service.
25.
Here, what has happened?
Lordship, same thing.
Okay, same. Office name dated 1/6. 1 to 14, huh? A performer respondent, no.
26.
Out of two appellant number two expired, doctor. I have already filed substitution application with setting aside abatement and lift.
Where is it?
That is to take with a catch up.
Appellant number?
Two, Lordship.
Who is appellant number 1? Is alive?
Yes.
What is appellant number 2 has any business out here?
Appellant number two expired.
What is the suit for?
Suit for declaration, recovery of position as well as for permanent.
You were the defendants?
Plaintiff, doctor. It was dismissed.
You were the joint owners?
Yes, sir.
Hmm?
Joint owner, sisters.
Then why haven't you filed that application?
Also legal hire of appellant number two is there.
Huh?
I have filed substitution application that is to take with the case record.
Mr. R. Ali appears on behalf of the appellant and Mr. For?
1, 2, and 3.
For respondent number 1, 2, and you?
For 6.
Mr. B. Deka
I'm for 4.
appears for the BD Deka appears for respondent number 6. And Mr. T.R. Gogoi appears for respondent number 4. The learned counsel for the appellant submits that the appellant number 2 had expired and substitution application and applications under order 22 have been duly filed in that regard. The said applications, however, are not there on report. Taking into account the same, the registry is directed to list this matter after 2 weeks along with those applications.
27.
As per order that 4/11/22, notice was issued to the newly imputed legal heirs of the sole respondent. Now, the service report is.
The service have been, they have been duly represented.
Yes.
So now records have come.
No, my lord, it is not admitted.
Oh.
2019 meter, but due to this meter lockdown, and this date of this sole respondent as well as the 1 million appellant also, this meter took time. And my lord, I have filed one I also for stay of the impugned judgment. It's not coming up with this record.
Then first it says to go under order to 41 rule 11. So taking into account that the service is complete, list the matter in the column of order 41 rule 11 after 2 weeks.
28 to 30.
This is also very matter for timing. Mr.
Why? No timing business in this one. Don't believe in time. Yes, what is your application?
I don't know how my case is stacked with the other.
Huh?
My case is this one.
No, whose is MFF 244 is whose?
It's our
Yes, tell me, madam, what is it?
Your Lordship, we have filed. the
Appeal has been
pending-
admitted?
Yes, appeal has been admitted and LCR has also come.
Then?
And it will be fixed for hearing, Your Lordship.
Okay. LCR has been come.
Lordship, I am for the respondent.
In all these appeals.
Except for item number 29.
appeal kita ko to ekelage lagi thi. Whose is 83?
Sir, wrongly tagged.
Wait,
wrongly
whose
tagged.
is 86?
86 in this, I am the appellant.
These are
We
cross
are there.
appeals?
Yes, my lord.
With both of you?
Yes.
Both of you?
Yeah, 28 and 30 is cross appeal and cross.
I mean, 244 and 86 is connected.
Connected.
It is beta ekelage. Heard Miss
M. Chatterjee.
M.
M. Chatterjee.
M. Chatterjee, the lien counts for the appellant in MFA number 244/2019, as well as the respondent in MFA number 86/2019. And Miss, your name?
M. Sharma.
M. Sharma appears on behalf of the appellant in 86/2019 and respondent in MFA number 244/2019. Both the appeals have already been admitted and the LCR has been received, taking into account the same, let this matter be listed for hearing in its usual course. Yes, now, what is your case?
My case is, my lord, death due to untoward.
Huh?
Death due to untoward.
Okay, here the records have come. You have not done this thing. Records of which? Not 83. We are concerned with the records of our railway claims criminal 151. Heard Miss? Mr. A. Alam, the learned counsel appearing on behalf of the appellant. Miss M. Chatterjee,
Yes.
you are appearing for the respondent.
I'm appearing for the
No, your lord.
Or Mr. B. Sharma appears for the respondent. Good stuff.
29.
It appears that the appeal has been admitted and the records have been received accordingly.
In 29 it's not received probably.
Received? Hey, received.
29.
Yes. We are concerned in 29 is the claim case number 151/2014, nah?
Yeah, 83 of 2019.
No, 151 of 2014.
Railway case, railway case.
Oh, railway case number.
Railway case.
Other MFA is 86.
And the
83.
LCR have been received. This is the matter for hearing in its usual course. Yes, madam, what is your case?
My lord, here lordship, Lord Court Accord was called for.
31.
Received, lordship. Lord Court Accord has been received, lordship.
Received.
And regarding lordship,
Oh, well,
service, response number 1 is appeared, lordship, and no response is received upon response number 2, lordship.
Service is complete.
Respondent number entered appearance, lordship, and 2, lordship, no such response received.
You are
So, may be allowed to
I
take
am for
this.
one, my lord.
the
For number
claimant.
one. Yes, ma'am.
And about 2?
2, that is lordship.
No, my lord, so far my knowledge, my lord, he has died. How can you have knowledge? My lord, some correspondence letter of the insurance company to the owner I have received, my lord. From this letter, it is clear that succession certificate wanted by the company from the wife of the owner, my lord.
When did you get this?
This is the letter of the 2013, as I have got recently.
This is by which company?
Company is a New India Insurance Company, my lord. That is the company.
Give me that document. So we dismiss the appeal.
Lordship, I'm sorry, I could not, I have not knowing, lordship, that there was some.
My lord, this is the letter, my lord. 3 letter is there, my lord.
I mean, like 2 days time, lordship, to obtain the instruction, lordship.
Company has a knowledge, my lord.
But there was no report in the office record, lordship, we have taken steps, but there was no report regarding death of the phone number 2.
Heard Ms. M. Chaudhary, the learned counsel appearing on behalf of the appellant.
Lordship.
Mr.
A.R. Mehdi, my lord.
A. Mehdi appears on behalf of the respondent number 1. It appears from the record that the service upon the respondent number 2 is not complete. Further to that, the records have already been received. Be that as it may, Mr. A.R. Mehdi, the learned counsel appearing on behalf of the appellant, respondent number 1 submits that on 28/11/2013, the divisional manager of the appellant company had written a communication to the wife of the respondent number 1,
Respondent number 2.
or respondent number 2, requesting for the successful certificate and her consent at the earliest, meaning thereby that the appellant insurance company had the knowledge that the respondent number 2 had long expired. Ms. M. Chaudhary, the learned counsel appearing on behalf of the appellant, submits that she wants to take instructions in the matter. You get a photocopy of this, huh? You can photocopy it. The documents dated 28/11/2013, so placed on record by Mr. A.R. Mehdi, so placed before this court during the course of the hearing, is kept on record and marked with the letter X. You can put a X mark on it. This is the matter of the 2 weeks.
My lord, later, date may be fixed, my lord, because that is a whole meter. They are not depositing the money also at the time of admit the appeal, my lord. No order is there.
Lordship, we are not pressing the stay law.
Fantastic. We dismissed the
No,
appeal.
Lordship, the thing is that
Hey,
Lordship, we are not
dismiss the-
liable to pay, Lordship.
No, you go to the Supreme Court. We dismiss the appeal. You have filed against the dead person.
This is,
You dismiss the appeal.
the thing is that Lordship,
You knew it very well, all these aspects of the matter, then why shouldn't we dismiss the appeal? And you are not pressing the stay.
no, pressing Lordship,
Then
that we have taken steps, Lordship, on that.
you are not, obviously you
Not
have
for the
taken
purpose-
steps upon a dead person knowing fully well. How much is the amount? You have no problem in making crores and crores of money and you can't pay this 3,44,000.
He himself brought, he himself met with an accident, Lordship. Due to his own negligence, Lordship, the accident occurred. No
Not
other vehicle
nothing
is
doing.
involved.
In I, my lord, there are also one order, my lord, from the court, my lord, 17 to 2020, my lord. Direct the appellant to furnish the
Okay, let us write this up.
Who have furnished, Lord?
Heard Ms. M. Chaudhary, the learned counsel appearing on behalf of the appellant. And Mr. A.R. Mehdi appears on behalf of the claimant. This is an application under Order 41, Rule 5. This is an application for stay of the judgment and award dated 15/12/2018 passed by the learned member Motor Accidents Claims Tribunal. Number 1, Kamrup, Guwahati in MAC case number 1638/2011. The grounds upon being perused, this court is not inclined to stay the order dated the order dated 15/12/2018. What is your case?
Lordship, here, Lordship, the case is that the claimant respondent, Lordship, he himself dropped the vehicle due to his own negligence, accident took place. And he is, due to his negligence, he is claiming the compensation. No other vehicle is involved, Lordship. Lordship, you will find the.
There is no other
search sheet-
vehicle.
Search it, no, Lordship. The search sheet
And who is he?
FIR.
Who is
He is
he?
the claimant, Lordship. He is the driver. of
I am
the
the
vehicle.
driver, my lord.
Maruti van himself met with an accident. No other vehicle is involved. And it's a private vehicle, Lordship. And the thing is that the FIR and the charge sheet is against him, Lordship. And he pleadings, he's saying something else, and in the evidence, he's saying something, and documents are different. Lordship. It's a fraud, Lordship. Lordship, you will find it in the evidence,
my lord.
after evidence, and the evidence also he has stated contradictory statement he has made. Therefore, Lordship, there is a scope for examination.
No. Upon perusal of the grounds taken and taking into account the grounds taken and taking into account the limited question of law, question involved as to whether there is a fraud committed by the appellant, by the claimant in making the claim. This court is of the opinion that ends of justice would be met if the instant appeal is directed to be listed for hearing on 28/6/2023.
Much obliged.
I sense this.
$32.
It please your lordship, there is delay of 113 days in filing the appeal, my lord.
What appeal?
My lord,
Service is not completed.
RSA.
RSA.
Service is not completed.
Madam, you are appearing for
Respond for 1 to 5.
1 to 5, my lord. That's
delay of
113 days, my lord.
113.
what is the reason?
My lord, stated in paragraph 9, my lord. My lord,
Will file objection.
Not file his reply.
objection.
Right, fine.
Service is not completed, my lord.
My lord, performer-
You are there for 1 to 5. Chalo. Heard Mr. V.K. Burwa, the learned counsel appearing on behalf of the applicant. Ms. S. Roy appears for the respondent number 1 to 5. And who appears for the state of Assam?
My lord, from 6 to, my lord, performer respondent 6 to 10, it may be strike off, my lord. Performer, my lord, they are not required.
The learned counsel appearing on behalf of the applicants submits that the names of the respondent number 6 to 9, who are the performer respondents, may be struck off. Accordingly, the names of the performer respondents number 6 to 9 are struck off at the risk of the appellants. The learned counsel for this is an application under section 5 of the Limitation Act 1963 for condoning the delay of 113 days in filing the accompanying appeal, so accompanying second appeal. The reason, the grounds mentioned have been mentioned in paragraph number 9 of the said application. A perusal of the said grounds, this court is of the opinion that the same constitutes a sufficient cause within the meaning of section 5 of the Limitation Act. Considering the above, the delay of 113 days is condoned. Accordingly, the I stands disposed.
Highly obliged, your lordship.
We cannot give a main call. Heard Mr. V.K. Burwa, the learned counsel appearing on behalf of that. The respondent, the registry is directed further to list the accompanying appeal under the provisions of Order 41, Rule 11 after 2 weeks.
A copy of the memo. Sir.
As Ms. S. Roy appears on behalf of the respondent number 1 to 5, a copy of the memo of appeal be served upon her by the appellant.
Highly obliged, your lordship.
33.
Please, your lordship.
Yes, Mr. Goswami, what is this file with all green papers, huh?
This appeal come for hearing because already heard on few days by.
As
Come in
agreed
orders.
by the learned counsel for the parties, list the matter on 5-6, heard at length. Why this shouldn't have been here? It was admitted on 2-3.
Yes, my lord.
Whether in the case filed by the EC Act, the Commissioner of India had the power to assess the wages of the earner arbitrarily against the evidence, whether so and so has the power to assess compensation by taking wages higher than that stipulated in so. A perusal of heard Mr. R. Goswami, the learned counsel appearing on behalf of the appellant, and Mr.
My lord, BK Das.
BK Das appears for respondent number 1.
1 to 5, lord.
1 to 5. A perusal of the order dated 2/3/2023 shows. No. It appears that the records have been duly received. Accordingly, list the matter for hearing. When?
My lord, short date, my lord.
Hearing after, immediately after the summer vacation.
Okay. My lord, may I pray one thing, my lord? My lord, summer vacation, my lord. Only that, my lord, the fact here in this, my lord, this matter has been fixed for hearing on 5/1/2022, my lord. Thereafter, my lord,
Next week, Lordship.
next, my lord, because my lord, humble request is that, my lord, this claimant hearing is just, my lord, who is the my lord, claimant in the, my lord, before the commissioner here in my lord, respondent. She's suffering from, my lord, some critical illness in dying bed, and her son was the, my lord, sole earning member. He expired, my lord. So, my lord, that is considering only that aspect, my lord. Any date, my lord, sort date as per your lordship, before vacation, as per your lordship convenience.
It is not convenient. I can't impose upon anybody. We'll have it after vacation. Give a date. Something around 20th of July. 27. 20. Hearing on 27.
34 and 35.
Contempt case. What is this contempt business? Yes.
Lord, my Pharaoh's office no dated 2/6/23, Lord.
Who is appearing for the government? What is this? Warrant of arrest have been issued and all?
The contempt case has been filed. So the matter taken after matter passed for the stamping, Lord. My stimulation.
Who is this?
Ek Anguli, Lord.
Huh?
Ek Anguli.
So? Court's order available warrant of arrest area. But why? No. Where is the government?
Government is not a party, Lord.
Huh?
Respondent.
Who is Babulal Gogoi?
But the CRP has been filed, and again a CRP has been filed, Lord. Against the order of the CRP, they have violated the order of the court. So contempt has been filed.
Then?
In the contempt zone, they are not appearing, Lord. So available warrant has been.
But we have to get hold of that government, na? Home Department, where is it? People normally appear. Hey, Kumaran Matokun, call the senior government advocate to take it up. What has been done? All the senior or anybody from Rahul Dhar, call. We'll take it up. Wait, something is going to happen. Follow.
April. Not in this case, we have filed our affidavit in reply, which is not a part of record, my lord. That is necessary. The matter pertain to the condonation of delay, my lord.
Itu ki main file tu sao?
IA, my lord, IN 215.
Delay, how much?
My lord, delay, my lord, 2,435 days.
And what affidavit in reply is required?
My lord, reply we have submitted because they, my lord, raised certain issues.
Definitely they will raise issues,
My lord,
rightly so.
against which we have, my lord, make our counter reply, my lord.
Huh?
There is nothing in the reply. Only denial.
2000 days delay, why?
The reason is that the matter was under litigations, my lord, because we have counted this order from that day of my lord passing from the original jurisdiction. Thereafter, my lord, appeal, review, revision, my lord, and thereafter, my lord, some other delay has also occurred.
Huh? How much time did it take for disposal of a review application?
My lord, normally, my lord, there is no time fixed for disposal of review application, but question.
How much time did it take for disposal of the review application which you filed?
My lord, it has taken time, my lord. I mean,
It took 2 years, Lordship.
Almost
2 years. They filed it on 28/5/2014, and there was a delay. It was not the main petition. It was dismissed.
When?
On 31/3/2016.
When? After that, when did you file?
my lord, thereafter we have preferred revision
CRP.
petition, my lord.
Huh?
Thereafter we have preferred revision petition, and that was written on 18/12/2018.
Then?
My lord, thereafter, my lord, this withdrawal was, my lord, thereafter no any advice was given for filing, my lord, proper application of, my lord, second, my lord, appeal. And in between, my lord, time has been consumed, my lord. Now, there, my lord, the element of section 5 and 14 both are there, my lord. And lordship has already decided in 2012, 22, my lord, that about that effect of section 5, my lord, that two elements are the sufficient was followed by, my lord, discussion exercise by this court on limited inquiry. But question is that, my lord, recently, my lord, one judgment is very important. That is how to deal with, my lord, section 14, my lord, that guidelines has been laid down, my lord, Supreme Court. Now, if suppose both elements are there, my lord, 5 and 14, how to deal with? Well, little time, my lord, I required, my lord, to just place one or two judgments, my lord.
Which judgment?
My lord.
Which judgment?
My lord, that because two elements are there, lordship decided 2022, my lord, 3 or 4 judgment I have perished, my lord.
Which one?
Section 5 part, my lord. But so far, lordship has already decided section 5 part where lordship decided that two elements are necessary.
Which element? Which one? I have decided a lot of section 5. Which
section
one?
5, my lord, lordship has decided in one judgment. That is, my lord, Osman Ali and Qasim Ali, my lord.
That's Mr. MA6 judgment.
My lord, no, it's my lord, it's not MSc, my lord.
MA6 was the lawyer.
Yes, my lord. Yes, my lord.
3,370
Yes,
days.
my lord. Paragraph 19, lordship decided. But my lord, my case is, my lord, some another domain of, my lord, both applications, section 5 and 14.
5 is different, 14 is different.
No doubt, my lord, because my case, my lord, was otherwise.
14 is a case where you are placing your matter before an authority which did not have the jurisdiction, but you were bona fide litigating.
My lord, my lord.
But what about those 4 years after the withdrawal of the CRP?
My lord, that's why, my lord, section 5, my lord.
How do you bring in 5?
Exactly, my lord. Prior to that, my lord, section 14 come into play, and afterward, my lord, 5 will come into play, my lord.
Chalo.
Lordship just need more little time, my lord, because today I have got one citation of my lord N. Balakrishnan, my lord. That is, my lord, decided about that. This is the Kalparaj Dharamsi and
There is no new principles decided by any court recently, Mr. Here.
My lord, one thing is that lordship kindly.
There is nothing new principle. The principle stands as it is, which have been.
But ultimately discussing, my lord, satisfaction of
No,
the
not
court,
only its discretion, it is a case of how you apply 5 and 14.
my lord.
14 is on a different perspective and 5 is on a
My
different
lord,
perspective.
my lord. In both points, I would like to satisfy lordship. Just need some time because, my lord, little preparation, lordship, I have to do, my lord.
Earlier also, many times.
No, my lord, prior to that, I have not actually happened.
Huh?
I have filed my only reply, my lord, last week.
No, but the sad part is, last time the matter got listed before this court in September 2022.
Afterward also, my lord. but
And
it
till
is-
now, nothing has happened.
My lord, afterward it is all listed, my lord.
No, it is not listed.
Not
Where
this,
it
my
is
lord.
listed? No. That was the last listing on by heard Mr. M.M. Jaman, the learned counsel appearing, Mr. S.D. Purkasta appears for applicant submits that his senior is not available.
My lord, afterward, my lord, matter was on, my lord, court list, but it has not been, my lord, reached. Anyway, my lord, little time, lord, if possible to accommodate, man, only these 2 points, man.
Hello, I'm temporary person here. It's a matter of the 4 weeks at the request of the applicant.
97.
My your lordship, I am for the appellant, my lord. I was supposed to file the certificate for who died, my lord, 2 respondent died, 2 and 6. My lord, some 4 weeks time may be granted, my lord. The appellant, main appellant is a very 70 plus age is unable to come, my lord, is suffering from some illness, my lord. So some time may be granted.
When did they die?
My lord, exact date I do not know, but around 2 months, at least 2 months, my lord, perhaps. Exact date is not known, my lord.
Your name?
A.K. Talukdar.
Heard Mr. A.K. Talukdar, learned counsel appearing on behalf of the appellant, whose request for an accommodation list the matter after 4 weeks.
Obliged.
38.
Yes, who appears here? CRPIO. What is this CRPIO?
I am for the opposite party respondent number 1.
What are these challenging?
Challenging the, my lord, the petition for to adduce evidence at the appellate stage. That pair was rejected by the
His
trial court.
application under order 41 rule 27 has been rejected.
Rejected
So
by the
then
trial-
that will be made a ground of appeal,
My lord.
isn't it?
Yes, my lord.
How is this maintainable under 227? Isn't it, Mr. Roy Chaudhary?
2012 PS. If I'm not wrong. Or 41 to 27. That has to go for LP.
I think the most appropriate thing would be 2012 8 SSC.
8 years. I was wrong.
Yes, my
8
lord.
years.
Ibrahimuddin.
Yes.
Yes, my lord.
Yes, Mr. Dhar. I was getting hold of you. If I did you. As you appear for all these police people, means the police. Now, what has happened here? These are 2 contempt matters which have been filed.
My lord.
This contempt matter was filed where there was an injunction passed by this court. And there was a direction by this court, a bailable warrant of arrest was issued by this court on 3/5/2023. Peruse the office or note dated 2/5/2023 and the communication dated 25/4/2023 of the Superintendent of Police, Punitpur. Nothing is discernible as to whether the warrant issued have been executed or not. None appears for the sole respondent. In that view of the matter, issue fresh bailable warrant of arrest against so-and-so. The Superintendent of Police Biswanath shall get such warrant of arrest executed through the officer in charge Gopur Police Station and produce a proof thereof. The date of appearance is 5/6. Now nobody has appeared. There's a communication has been received from the office of the surveyor. The communication states that a copy of the bailable was sent to the Gopur Police Station for execution. However, to date, no execution report has been received from either the office of the Superintendent of Police Biswanath or Gopur Police Station. So you take the appropriate thing.
My lord, this is a contempt matter, my lord.
No, that is what I am not on that.
No, my lord, I am just trying to understand the situation, my lord.
No, you see what has happened.
My lord.
There was an stay order passed by this court.
My lord.
That order was violated, for which they have filed a contempt. Now that person concerned is not appearing, for which this court issued a bailable warrant of arrest. This bailable warrant of arrest was directed, the Superintendent of Police Biswanath was specifically directed to execute it through the Gopur Police Station. Now the Superintendent of Police writes by way of a letter on 10/5/2023 to the officer in charge that kindly execute the bailable warrant. There's nothing else. We don't know anything else. So how to do this?
My lord, this contempt is fall out of a writ petition, my lord.
The Superintendent of Police is not a party to the proceedings.
My lord.
It is only the execution of the bailable warrant.
I will get it done, my lord. Just,
Huh?
I need a copy of the order, my lord.
Yeah.
I will get it done.
You just guide them.
I'll guide
What
them,
has
my lord.
happened?
My lord, I will
Because they should know. I'll fix another date.
My lord.
Now, would this court have to issue again a fresh bailable warrant of arrest now? Because that has not yet been executed.
My lord. I will pass necessary orders. I will get it done, my lord.
Could I put your name?
Oh, my lord, my lord. As a government council, my lord.
Order to, peruse the office note dated 2/6/2023. As well as the communication dated 10/5/2023 issued to the officer in charge of Gopur Police Station by the Superintendent of Police Biswanath. It, however, does not appear as to whether the bailable warrant of arrest so issued by this court have been executed or not. Mr. Ardhar, who is the additional government advocate,
Additional
senior government advocate, who was present in the court, was requested by this court during the course of the hearing to take note of the above as to whether to take of the note pertaining to the instant matter. He submitted that he would appropriately advise the Superintendent of Police, Biswanath, to do the needful. Accordingly, this court issues a fresh bailable warrant of arrest of rupees 10,000 against the respondent Sri Babul Gogoi, son of late Konak Chandra Gogoi, village Pranjal Nagar, PS Gopur, in the district of Biswanath, Assam. This, the Superintendent of Police Biswanath, District Biswanath, shall get the said warrant of arrest executed through the officer in charge of the Gopur Police Station and produce a proof thereof. The date of appearance of the respondent is fixed on 19th of July. Would it be too long?
That will be too long, man.
Too long, no? We'll have it on 29th of June. 29th of June. Full stop. The court master, no, the registry shall do the needful to intimate the Superintendent of Police Biswanath about the instant order. The court master of this court shall also serve a true copy of the instant order to Mr. Ardhar, the learned additional senior government advocate, for due advice to the Superintendent of Police Biswanath. Sorry. Yes, Mr. Sikdar.
My lord, the petitioner side has lost the interest in the case, my lord.
Lost interest?
Yes, my lord, there is an order of 25/5, my lord.
25?
Office note, my lord, 25/5.
25/5/2022.
23, my lord.
I stated that to have been filed by the petitioner could not be traced out by referring to computer software laid out. What is it challenging?
My lord, they have, my lord, filed a petition under order 41 rule 27.
Oh, that one.
was rejected by the trial court. Then they
But
appealed.
isn't it that if they are aggrieved by that order, they have to only file an
Yes,
appeal
Yes, my lord.
in a regular course?
My lord. In appeal, they have filed another petition. My lord, then
They have
that was
filed an
rejected.
appeal?
Yes, in appeal, they have filed a miscase. My lord,
They have
under
filed an
order-
RSA?
No, my lord, in the first appeal court, first appellate court. my lord.
No, this order is passed on the order 41 rule 27 means it is an application before the first appellate court.
That
So-
was rejected. my
So that was rejected. Against that, they had to come
Yes.
only before this court at the time of after the decision,
lord. Yes, my lord.
not before that.
Not before that.
None appears on, who will dismiss it? None appears on behalf of the appellant. On the petitioner on call, Mr. A.R. Sigdar appears on behalf of
Respondent number 1, my lord.
respondent number 1.
1 and 2, my lord. 1 and 3, my lord.
Respondent numbers 1 and 3. 1 and 3. What about this 3A, 3B?
My lord, who has died, my lord? They have
1, 3A.
Yes,
You are
I
paying
am
for 3A, 3B and
Yes,
3C.
my lord. All three.
3B and 3C. Good stuff. Taking into account that none has appeared on behalf of the petitioner, the instant application stands dismissed for non-prosecution. The interim order so filed, the interim order so passed in the instant writ petition stands vacated. But one thing is, why did he decide out of 41 rule 27 before? He shouldn't have decided that.
My lord,
What else?
there,
If we go by Ibrahimuddin,
My lord.
it categorically mentioned on a particular date.
yes,
That is at the time of final hearing. At the time of final hearing, yes, he finds out, yes, on these facts, I can't deliver the judgment on this basis, and as such, he will give it.
they have not waited for that, my lord.
They have not, no, the court have not waited for all these things. Hello, anyways, interim order, if any, then repeat.
Biplab Lailas.
39.
Yes,
May I beg your lordship? Matter may be adjourned for
Why?
1 week.
I don't
My
adjourn
senior-
this. CRPIO matters are,
Yes, actually,
as per me, the first date is on the date of motion, and the second date is on the date of dismissal or allowed.
yes.
Now show me what is it, what you are asking for.
Actually, my senior counsel has been suffering from typhoid,
Not okay.
and Mr. A.K. Rai
Therefore,
is not
considering the
associated.
relevancy of the source sought to be exhibited, I deem it best to allow the prayer. Plaintiff is allowed to exhibit the certificate of registration of the plaintiff form in the court. What is the stage of the suit when it was allowed?
It was kept in abeyance.
What was the stage of the suit when this order was passed?
I have to gone through the record actually.
Madam, I am allowing you a petition, just find out what is this. First of all, you don't appear before this court without knowing it. And if you appear out here before this court without knowing it, then you put yourself in a lot of great jeopardy. You are the plaintiff?
Yes.
Cross-examination over?
No, your lordship, actually, I have.
Don't
filed-
make the repeated argument out there. My senior knows everything, I don't know anything. What is wrong with this order? There's nothing wrong with the
Actually,
order.
we have filed a petition under section 30 or read with order 11 rule 14. And
Your
honorable-
petition was allowed.
No.
Your petition was allowed. You are the plaintiff,
Yes, unique lot, unique trade
trade
agency.
agency. Yes. What is that order which is being passed? Stating that the plaintiff had no legal sense to ask for the statement of account. Plaintiff firm has wrongly responding the three numbers. What about the other side?
Actually, we have taken consent of the other side that we are taking adjournment today.
Your name?
MSD Burma.
Heard Ms. M.S.D. Borman, the learned counsel appearing on behalf of the petitioner. None appears on behalf of the respondents on call. This is the matter after 2 weeks.
40.
Lordship, I may have to take steps. Service is not completed.
Have you taken steps?
We took steps.
Have been AD or respondent number 2 has been received back with the signed by one Rubul Deka and the same is placed on record. Unserved notice of RIA for necessary to enter have been issued, flag one insufficient address. Address is not known. What do you propose to do?
Lordship, the address was given by them only in the title appeal. One thing. Secondly, we may take the trustee service also. Lordship, there is another second appeal out of arising out of the same judgment. We may give a copy to the respondent's advocate.
It appears on record, heard Mr. B.K. Bhagavati, the learned counsel appearing on behalf of the applicant. It appears on record that the service upon the respondent number 1 and 3 is not complete. The applicants are directed to take fresh steps upon the applicant numbers, respondent numbers, opposite party numbers 1 and 3. By way of registered as well as usual within 7 days. Further to that, the applicant is also directed to effect service by way of dusty routed through the registry of the spot and file an affidavit of service on or before the next date. Leave the matter on 26th of July 2023.
Forty-one.
So this is the IFO condemnation of delay matter.
How much?
829 days.
We'll file objection, my lord.
Heard Mr.
A Boro, my lord.
A. Buru, the learned counsel appearing on behalf of the applicant, Ms. S. Roy
I am
appears on
appealing for the
behalf of the
respondent number
respondent
1,
numbers
1, 3, 4, 5, 6, and 7.
1, 3, 4, 5, 6, and 7, who submits that they would like to file objection to the same. Accordingly, list the matter after 4 weeks.
Last time also they took time to file objection, my lord. So court date may be.
It is made clear that no further adjournment shall be granted on taking time. As on the earlier occasion, the said respondents had taken.
Right. Obliged, my lord.
42.
Yes, Mr. Das,
My learned friend filed objection today, my lord,
for what?
for delay of 369 days, my lord.
Delay is
filing-
actually not 369 days, Lordship. Actual delay is 1162 days.
My good.
Second appeal was dismissed. for-
Even the electricity department is shocked with Mr. Das. See what is happening?
Case was dismissed for default, my lord. And thereafter review order was passed, my lord. The restoration not.
Huh?
Case was dismissed for default, my lord.
Then
Thereafter, my lord, review petition filed, my lord. And there is a delay of 369 days, my lord, according to me, my lord.
you have filed an objection.
Yes, Lord.
It has come on record.
Lordship,
It was pending case second appeal of the year 2002, my lord.
Huh?
Pending second appeal was of the year 2002. Once
Then rightly dismissed.
earlier set of counsel different, my lord. That's why, my lord, they were not.
Let me see which are the grounds of, what is the ground?
That is, my lord, page 18, my lord.
No, what is the substantial question of law?
Oh, yes, my lord.
Heard in part. See?
Hmm.
Matter was heard in part by Justice Agarwal.
Yes, my lord. Set of counsel were different.
One fine day, Mr. Das becomes a judge and he retires, then also this matter won't end. Me say that not before.
Application under 41 Rule 19 was dismissed, Lordship.
Huh?
Condonation application was filed.
No,
for-
where is the appeal have been admitted?
Yes, appeal was dismissed twice.
No. First show me where is the appeal which has been admitted. Where is the order of admitting the appeal? When was it admitted?
It was long back.
Got it.
Appeal
Whether the
was
suit for
2002.
declaration of title and recovery of possession without praying for partition of the land is maintainable in law. Not maintainable. Then you don't have a case. Matter ends.
I have to go through this, my lord. He
Hello?
has filed objection, my lord. Limited case is
We
on
dismiss
merit.
it on the right, okay. We condone the delay and dismiss the appeal. At whatever may be, it may be brings a quietus to the matter. He'll be also happy. You'll be also happy after so many days you have been able to condone. You may have a face saving before the client and he'll be happy. They say, look here, we got the matter dismissed. At the end, that's everything happens and
Day
there's
after tomorrow,
nothing.
my lord. Day after tomorrow. I have to go through this second appeal.
After dismissal of appeal, they filed an application with condonation, delay condonation for order 41 Rule
On merit,
19.
my lord, I have not.
Section 5 application was dismissed, Lordship.
A different three set of counsels were there, my lord.
Now
Counsel I
against
have got.
dismissal order.
No,
of
these
section 5, they
matters,
filed
Mr.
review
Counsel,
application.
needs to be finished up and pressed out.
Day
These-
after tomorrow.
Not day after tomorrow. Day you escape from me.
No, my lord. But Thursday also, my lord, I am ready, my lord.
I
Otherwise,
am
have
not
to-
here. I won't be here. I'm only sitting for these 2 days. Leave the matter after when?
Any date subject to lord.
After
Friday, Lord.
vacation.
If possible, kindly fix for Friday, Lord.
At the request of the learned counsel for the party, matter sent adjourned till 9.
I will.
43.
এখন কি বাকি বুগি?
My lord, I-8301, my lord. This is for restoration of the, my lord, appeal. My
File within time?
my lord. Delay is condemned, my lord.
Huh?
Delay is condemned, my lord.
None appears on behalf of the appellant on call.
We had
None
taken
did
steps, my lord.
appear on for the appellant on so and so. However, Mr. So and so, learned counsel for the appeal represents, and in view of the matter, the appeal is dismissed for non-prosecution. Who appears for the other side?
Other side, my lord, we have taken Dusty service also on insurance company, my lord. Respondent number 2, my lord.
Have you served a copy to Miss L. Sharma?
Yes, my lord. This is the notice, my lord. She has signed and accepted, my lord.
No, no. We restore subject to deposit of cost.
Yes, ma'am.
$10,000. You are the claimant.
Yes, ma'am.
But why didn't you appear for so many occasions?
My lord, my name was not reflected, my lord, in the cost list. I have annexed the cost list also, my lord.
Whose name was
My
reflected?
name is, my lord. My lord, at page 16, my lord.
G. Agarwal, RK is signing. Who are they?
Yeah, they are the junior council, my lord. Junior council means they are practicing for.
Who is respondent number 2 is who is respondent?
Reliance, my lord.
Huh?
Respondent number branch manager, United in India Insurance Company, my lord.
And what about one?
One has been, my lord, we have served notice on him, he didn't come. Even in trial court also, it is an expertise order against him.
But the other side is not there. You
Madam,
appear for United India? Madam S. Roy. You don't appear. Who appeared? In the amongst the consortium of insurance companies?
My lord, on as per order 35, my lord, 2023, my lord, a direction is given by this honorable court, my lord, to give our, my lord, copy of the petition, my lord.
Can't help it, madam, it is not there. Heard Ms. M.D. Chaudhary, the learned counsel, appearing on behalf of the applicant.
My lord, they have,
Applicant, none appears on behalf of the respondents, taking into account the above. This court. Where is the notice issued? No notice has been issued till now.
yes, my lord,
No. In this case, no notice has been issued.
yes, my lord, justice service has been made. To
No,
the,
it can't be. There is no order. There is only one order of Justice Nandi. There is no other order.
no, my lord, in that order, 35, my lord, on
3-5 it categories say it appears so and so that on that day so and so Miss so and so who is earlier presenting maybe served a copy. List the matter after
Yes,
2
ma'am.
weeks. Then what about one?
one, my lord, we have already taken long time back.
No, you have to press tape. This is dismissed for default. Then
My lord, my
so
lord,
none appear. No.
there is a note, my lord.
Heard Miss M.D. Chaudhary, the learned counsel appearing on behalf of the applicant, issue notice upon the respondents,
My lord,
returnable by 6 weeks. Steps be taken by way of registered as well as usual within 7
my lord,
days.
we have been taking steps after steps, my lord.
Madam,
On the.
no, madam, you just show me where you have taken steps here.
On
Show me.
number 1.
No, madam, you show me. I'm telling you, there's nothing. That is why I'm saying it.
My lord, office note can be, my lord.
There's no office, no, there's no order for taking steps. Why have you taken steps then? There's no order.
Even on respondent number 2, my lord.
No, it is only mentioned that you are going to serve to.
On delay condonation, my lord.
I'm not on delay. There's a delay application.
Yes, my lord, that has been condoned. There, my lord, I had taken even dusty service on respond number 2. 2300, my lord, I. And my lord, the insurance.
That is okay, but here also you have to take steps because this real notice has not been issued. That is delay condonation, it has happened. 44. Yes.
So in this case, expert injunction was granted. They filed a bakalatama. Let the matter be for admission.
Ex parte injunction, why with this CRP business?
They did not filed any.
What is this CRP?
CRP
Against an injunction.
Injunction.
Ex parte injunction has been granted. Then who has challenged it?
No, I'm saying in this honorable court have granted. On 20.
I'm not on that. Who has challenged this order? It's an order. You are challenging what order?
We challenge the judgment decree dated 25/11/2000.
This is under section 6.
Yes, sir. Specifically, sir.
Then
And then the officer had not appeared, and again on we have filed.
you are appearing for?
Sir, Lordship, I am appearing on behalf of P. Sharma, Lordship. He was here, but due to some personal difficulties, he has to rush to home.
Heard Mr. J.
J. Das.
Appears for the respondent, none appears on behalf, or you appear for? Your name?
R. Chitri.
And so appears for the respondents. Please the matter after 4 weeks.
45.
Yes.
Lordship, there's a delay. There's an IA application. There's a delay for 250 days in preparing the regular past appeal. Lordship.
Here it is mentioned 250 days.
250 days. Lordship.
Then what is your play?
I haven't filed my objection yet.
Why should you file objections for this? You want to fight him tooth and nail, but what is this filing on the
Only difficulty is the ground, my lord.
Yes, what is the ground?
Ground, they say that the matter was settled between the parties, which is why they did not pursue, my lord. That may possibly have an impact on merits, my lord. Paragraph 2, your lordship picks up. Otherwise, delays.
We can condone it, saying that the observations are only on the ground of sufficient cause without ascertaining the veracity of the statements made. Unnecessary, why should you keep pending in the end of the day? Because the problem is, one day or the other, at the later point of time, this delay application will be condoned. And then this matter gets pending for another 10, 15 years.
That way, my lord, it's easier. I can press for a deposit also because it's a money decree. But only
Then-
thing that worries me is if today your lordship holds that there was in fact a settlement, then my lord, it may impact the merits.
No, that we are not deciding on that. I'll note it out there that there was no settlement. However, on the basis that there is a sufficient cause, we are condoning the delay without affecting or whatever it. Heard Mr. R.K. Bhuiya, the learned counsel appearing on behalf of the applicants. Mr. B.D. Deka appears on behalf of the respondent numbers 1, 2, 1 and 2.
1 and 1. 1, 2, and 3. 1, 3, 4.
1 to 4.
1 to 4.
1 to 4. Hey, is this have any connection with that property? Jarnail Singh. Mr. Deka, did I appear in this matter earlier somewhere? No, no.
My lord, I got engaged subsequently. I was told initially Mr. Jha was appearing.
No, for party.
No, no.
No.
Which property is this?
This property is situated.
Near Kar Bhavan?
It is at.
Is it near Kar Bhavan?
No, no, no.
No, no. There was another person, no?
The property is situated at Rukmini Gaon.
You were also appearing in that matter, no? What is that? That person, the liquor baron?
No, no, Rajesh Jalal.
That is another matter, no?
That is not.
Another bit.
But these people were there.
Yes.
I'll have to check on that.
But anyway, I didn't appear in this matter. This is an application under Section 5 of the Limitation Act for condoning the delay of 250 days in filing the connected appeal against the judgment and decree dated 28/4/2021 passed by the Court of the Civil Judge number 2, Kamrup Metro at Guwahati, entitled suit number 434/2018. The learned counsel appearing on behalf of the applicant submits that on account of certain negotiations and compromise,
With the predecessor of the respondent.
huh,
With the predecessor of the respondent.
with the predecessor of the respondents. Now, that means that as there was some negotiation and compromise with the predecessor of the respondents, the appellants did not file an appeal against the judgment and decree, against the impugned judgment and decree in the accompanying appeal. And as a result of which there has been the delay. On the other hand, the learned counsel appearing on behalf of the respondent submits that there was no negotiation or compromise with the predecessor of the appellants, predecessor of the respondents, as alleged in the application. The fact as to whether there was a negotiation or not is a question of facts which should only, if gone into in much detail on the basis of evidence, would only delay the adjudication of the accompanying appeal. Taking into account the above, this court therefore finds that there is a sufficient cause, finds that the grounds alleged constitutes a sufficient cause for the purpose of condoning the delay of 250 days in preferring the accompanying appeal. It is, however, observed that the findings, that the observation that and accordingly the delay of 250 days in filing the instant appeal stands condoned. The registry is therefore directed to register the accompanying appeal and file and accompanying appeal and list the matter for admission in the next 2 weeks. It is made clear that this court had only, on the basis of there being grounds constituting sufficient cause, have condoned the delay. The same should not be treated. The averments otherwise should not be treated that the petitioner, that the respondents have admitted the same.
Only correction on that, because of the settlement, they say they stopped appearing in the suit, which is why ex parte decree was passed. Your Lordship has perhaps said that because of the settlement, they did not prefer the appeal. They say because of the...
It is the case of the applicant that in view of the settlement between the applicants and the predecessor of the respondent number 1 to 4, the applicants did not appear in the said appeal, which had resulted in the suit, which had resulted in the ex parte decree passed against the applicants. This aspect of the matter, however, has been denied by the respondents numbers 1 to 4 on the ground that there was no settlement or compromise between the predecessor of the respondent numbers 1 to 4 with the applicants.
Copies of the
Adjust.
Forty-six.
Yes.
Lordship. Lordship, the IA is lordship for conversion of delay lordship 36 days and already notice has not been served lordship. Not served. Just return answer lordship. Office not dated 2/6/2023.
The office note dated 2/6/2023 shows that a service upon the respondent, sole respondent has not been complete. The petitioner is therefore, the applicant is therefore directed to take fresh steps upon the respondent by way of registered as well as usual within 7 days. The applicant is further directed to take dusty service upon the applicant, upon the sole respondent, routed through the registry of this court and file an affidavit of service on or before the next date. This is the matter again on 28th of July. Wait.
Forty-seven.
Ito matter. Yes. I for what?
My lord, I am respondent number 1. I have filed one IA that is 965/2023.
Yes.
For release of deposited amount that 50% amount was deposited by the insurance company. That amount is required by the
Who are you?
respondent. I am claimant respondent. Then
Okay.
Niranjan Deka,
Your name?
SC Pandit.
Heard Mr. S.C. Pandit, the learned counsel appearing on behalf of the applicant, it was IA 965 day. And Miss so and so appearing on behalf of the insurance company, insurance appellant company. This is an application filed for releasing the amount of rupees 8,24,800 deposited by the appellant in pursuance to the order dated 24/8/2022. In pursuance to the order dated 37/2022, passed by this court in the accompanying appeal. Full stop. This court, upon perusal of the materials on record, is of the opinion that the petitioner, that the interest of justice is be met if the petitioner, the applicants are allowed to withdraw the said amount by the registry of this court upon what? Upon due verification being conducted by the registry as regards the identity of the applicant. I stands closed.
But in the main appeal, we have allowed to take fresh steps upon respondent number 2, Lord.
Ms. So-and-so appears on behalf of the appellant. She submits that she may be permitted
So, substituted manner.
4 weeks' time for taking fresh steps upon the respondent number 2.
So, substituted manner.
And I'll respond number 1 file objection in regard to the IA.
Not I in appeal, Lord.
Appeal.
Appeal.
She may do so. No, well, not substitute service. Substitute service, you have to file an application. Did you file an application? Then so submits that so and so that she may be permitted to take substituted service upon the respondent number 2. I mean appeal. Liberty is given to the appellant to take appropriate steps for filing appropriate application seeking such relief. This is the matter of 2 weeks.
Date of appearance. Date of appearance.
Of?
In the paper publication, date of appearance.
I'm only giving you the liberty to file an application so that I can give you substitute service.
Lord, before my learned friend start, my lord, one thing is that my
48.
lord, under order 9 rule 13, my lord, revision petition has been filed, which is outright not maintainable.
Well, let me.
And second thing is, my lord, there is 2-year delay of the interim order. That test may kindly be looked into.
My lord, I am the petitioner here, what has happened, my lord. The respondent number 1.
What is this order 9 rule 13, where it has been filed?
My lord, they have filed an application for setting aside the dismiss for default. Along with that, order 9 rule 13 for setting aside the degree of my counterclaim, which was allowed. Both of the applications were allowed after a delay condemnation application, against which I have come before your lordship. There was a common judgment for which I have come before your lordship in a 227. They, as a plaintiff, filed a suit for right title and interest. After some days, they failed to pursue. I filed written statement and counterclaim.
No, if an application under order 9 rule 13 is allowed, then you come under 227.
My lord, order 9 rule 13, my lord, is an appealable. Order 43, I have seen it, my lord, is appealable. Now, order 9 rule 9, my lord, because it was a composite judgment, my lord, it's a total judgment.
What is this order 9 rule 9?
My lord, order 9 rule 9, my lord, for my lord, setting aside the dismissal of the suit. But here in the order,
Their suit was dismissed.
Their suit was dismissed and the counterclaim was allowed. My counterclaim was allowed.
Okay. So,
your lordship is
no, understood. But order 9 rule 9,
order what
suit was dismissed for what?
My lord,
where you appeared.
My lord, they didn't appear.
So it was done under order 9 rule 8.
My lord, here in the order 43, an order under rule 9 of order 9 rejecting an application in a case open to appeal, or an order to set aside the dismissal of the case, rejecting an application, and an order under rule 13 of order 9 rejecting an application in a case open to appeal, for an order to set aside decree past execution. Here both the cases were allowed.
So you say when the application was allowed, so there is no question of filing an appeal. You have no power. It will come under 227.
Rejecting an application. If their application would have been rejected,
then an order under order 9 rule 30 rejecting an application in the case of Iman for passing and setting aside an Iman expert. So their application was allowed.
Now their application was allowed.
So 227 will lie.
Lordship, kindly see order dated 5/11/2019, page 69. 5/11/2019, page 69. This order they put on the challenge, paragraph 2. The application 1805/2017 was filed by C. Sonalipi Bora, the plaintiff of PS so under order 9 rule 13 of the CPC read with 151 CPC for setting aside the judgment degree dated 14/7/2017 passing counterclaim filed by the defendant number 3 in title suit number 22,023. My lord, against which there is a very clear position. My lord, the order 43 rule D.
No, but Mr. Samar.
So far, their counterclaim is concerned. My lord.
Understood, but that counterclaim was decree. You filed an application.
My lord.
Your application was allowed.
My lord.
If your application was rejected,
my lord,
then only appeal would have lied.
No, my lord, there is no such thing. Any order passed.
No. Read it. Order 43 rule.
See, my lord.
Order 43 rule.
My lord.
An
appeal lies from the following order under the provision of the section 104, namely C. D. An order under rule 13 of order 9 rejecting an application in case open to the appeal for an order to set aside decree passed ex parte.
So rejecting, the moment if your application would have been rejected, then you could have filed an appeal. But your application was allowed.
My application was allowed.
Then how do you file an appeal? Same is the case of order 9 rule 9 also.
My lord.
If your application would have been dismissed, then you could have come. But if your application is allowed, he has no other recourse because then it becomes a part of the suit. Huh?
My lord.
Once your application is allowed, the suit is reopened. So therefore, the CPC does not provide. So we have to only see within the contours of order to Article 2 to 7. whether it-
Now, the second
There
aspect
was
of
a
the
stay
matter is
order.
that, my lord, a report
There
has
was
been
a stay order. They filed an IA saying for modification of the order. So my lord, they said that we are constructing, so there was a status quo order. So there was a direction from this court that my lord, there should be a police observation, a police report. Then my lord, both the occasions in order dated, my lord, first order was 24/23 in IA and then 16/5/23 where they have submitted, the police visited the spot. That was their submission. But my lord, I didn't find a
No,
report.
no, I don't understand why are these interim orders being passed by this court? If there is a police investigation required anything constructed, why that was not approached out there in that court? Trial court. The trial court is open with the suit.
My lord, the status quo order was passed from this court and they made
Status quo for what?
no, it's not a status quo. My lord, there was a stay order. Stay order. It's not a status quo order. Stay order. There was a stay order. Sorry, I made a wrong statement. There was a stay order. So as there was a stay order, well, they want saying that there was a stay order and they are constructing. So there was an observation for a police report. Whether I objected that there was no construction going. So the honorable court directed to go for a police observation.
Then
my lord, that is my restriction. But thereafter, whether there is a report has come. Last occasion in the order dated 16/5/23, they made a submission that in the IA 936.
Huh?
IA 936.
Your item number is what?
48, my lord.
48. Now, what is required to be done here?
My lord, report is awaiting, my lord.
What report?
My lord, the report from the officer in charge of the Nova police station, my lord. Last two occasions it was called for and he didn't submit, my lord.
Why should we go into all
My
this?
lord, reason is that, my lord, they are apparently, my lord, violated.
No, a simple question is whether the decision taken by the court under Order 9 Rule 13 was rightly done or wrongly done.
And along with that, Order 9 Rule 9.
My lord, while my lord, they stay
Why
order.
into all these peripheral litigations and all?
My lord, there is a reason, my lord. My lord, once my lordship not allowed me to.
Your lordship may take up for disposal.
Lord, friend, kindly just
tomorrow
allow
or
me to
day after
submit my
tomorrow.
part also.
What?
Tomorrow or day after tomorrow. Because
no,
your
no,
lordship,
no, no.
as your lordship says, you will be going out.
Now, yes.
My lord, after passing the stay order in their favor, my lord, they took the advantage of the situation. At my lord, war footing, my lord, they started the constructions.
Construction of what?
That in the suit premises, my lord.
Why, what did you construct?
My lord,
On
thereafter, my
submission,
lord,
we are not constructing.
my lord,
I
thereafter,
am absolutely opposed.
Understood. What is your suit for?
My lord, my suit was also for right title interest. And their suit was also for
And what?
right title. I am not asking for a cash position, my right title interest in the counterclaim.
No. You are asking for right title interest without confirmation of possession.
My lord, a confirmation of my in the my lord counterclaim. My prayer is there, my lord. I have annexed the counterclaim.
now afterward, my lord, this order was passed. Once they started construction in even application, my lord, for seeking my lord stay, and that stay was granted not to carry out any construction. Thereafter, even they carried out.
No, wait. Yes, what is your case? Yes, what is your case, Mr.
My
Samari?
lord, my case is about my lord, right title interest and my lord.
And
other-
recovery?
Yes, my lord. Recovery, my lord, also is the part of my.
In the counterclaim, my lord, I was directed to be put into possession. I was not in possession.
So you were not in possession?
My lord, in page 39, my lord.
No, you are not in possession.
Not in possession. The court said, and the counterclaimant be put into possession over the said land by evicting the plaintiff opposite party.
So you are in possession.
And
if you are in possession, how is he constructing?
My lord.
If you are in possession, how is
But
he
my lord,
constructing?
by applying their force, my lord, power, etc., my lord, they forcefully entered into the premises, my lord, and started their
So
construction.
isn't that a separate cause of action?
My lord, no doubt, my lord, question that after passing
Why
an
should this
order,
court look into all these things? When they do you, it's a separate cause of action, you file a separate suit
my
for
lord,
that.
since my lord, once that order was passed by the honorable court, they violated, my lord. Therefore, we have sought for injunction, my lord, that they should not be allowed to carry out any construction. This order was
But
passed.
are you therefore saying now they are in possession?
As on today, my lord, we are one. My lord,
Then
this is
how
a big-
can he
my lord,
construct if
this is
he
a
is
big
not in
property, my lord.
possession?
My lord, ultimately the position lying in our hand, but because my lord, they are applying their force, my lord, they forcefully enter into the premises, my lord.
But how is he constructing if
My
you are
lord,
in
My
possession?
lord, there is a dispute, sir, no doubt, my lord.
No,
He-
there's no dispute. If your case is that you should be confirmed in possession, how is it he is constructing? And when the decree has, the counterclaim has not yet been decreed.
Yet to be decided, my lord.
Has not been executed. Counterclaim is theirs.
Counterclaim is mine.
That was allowed.
Now that was allowed, then it was set aside. Decree was set aside. And their,
So you are against their application.
and their suit was restored. Because this was for default.
The copy of my plaint were not enclosed by them, my lord, but I have collected, my lord. Anyway, my lord, the report is awaiting, my lord. Lords may give a date so that the report may come, my lord. Let reveal the actual picture, my lord.
There is an order of no construction to be made.
My lord.
But how do you? No, this report. Tell me whether this report has been communicated.
Yes, my lord.
How do you know?
My lord, police has also visited the place, my lord. And my lord, in our presence, even we also contacted the police and also restrained them from paying out further constructions. And they said that they will submit the report before this honorable court.
Then
pursuant to the
no
order.
report. To Mr. S. Samaria, the learned counsel for the applicant, Mr. P.K. Roy Chaudhary, appears on behalf of the opposite party. It appears that this court had directed the officer in charge, Nagaon Sodar Police Station, to submit a report. However, no such report is available. List the matter again on 26th of June 2023. The registry of this court is directed to communicate the officer in charge of Nagaon Police Station with the orders dated 24/2023 and 16/5/2023. The officer in charge shall without fail submit the report on the next date so fixed.
Can I make a small prayer, madam, with a lot of permission? For the interim order passed earlier shall continue. It was for a particular date.
No, the order is not till next day.
But in the main.
No. Here it says no.
The main case.
No. Why should I say that? Till next day? Okay. The interim order dated that order our order to the IA 1001 of দিব দেই এতিয়া আপো 936 ত এটা order দিব heard so and so the applicant and Mr. P.K. Roy Chaudhary, the learned counsel for the opposite party. The interim order dated 4/4/2023 shall continue. As well as continue till the next date. I 10291 of 2022 Plekiriva heard Mr. P.K. Roy Chaudhary appearing on behalf of the petitioner. Mr. S. Samaria appears on behalf of the respondent number 1, and Mr. S. Khan appears for respondent number 3. The interim order passed earlier shall continue till the next date. List again on
26.
List again on 20. Interim order passed earlier shall. Yes.
Your Lordship, this petition is filed for honoring the delay of 1 day for filing
you're
for
there?
petition.
Heard Miss
And they,
the learned M
and
and D, the learned counsel appearing on behalf of the applicant. Mr. D.
Mohanto.
Mohanto appears on behalf of the respondent. The instant application, in fact, this is for condoning the delay in CO, filing cross objection. Don't require this, otherwise we do one thing. This is done under order 41 rule 22. Taking into account the provisions of order 41 rule 22 of the code. Which mandates that this court have been granted, this court being the appellate court have been granted the discretion to grant further time as may deem fit to allow. This court accepts the accompanying cross objection number 16/2020 to be filed within time. Considering the same, the instant application being IA civil number 1350/2023 is rendered infructuous. A cross objection of heard Miss Ende, the learned counsel appearing on behalf of the applicant, cross objector, and Mr. D. Mohanto appearing on behalf of whom?
Respondent.
Respondent. Of objector and appearing for the respondent. Good stuff. The instant cross objection is admitted. Records Aile?
I said.
You have got extra copy? You have got copies?
Yes.
As the notices have been duly served, list the instant cross objection for hearing along with the accompanying RFA number 40/2020. $54. Okay. 54. Yes.
May it please your lordship. Lordship, please I is for substitution of the legal heirs of respondent number 1 and condonation of delay in substituting the legal heirs and setting aside abatement.
How much?
365 days.
Huh?
365 days delay, lordship.
Issue notice. You appear for?
I am from the respondent also.
You're opposing?
So 1,135 days is
You're
delay.
opposing. Issue notice. Heard so and so. The learned counsel appearing on behalf of so and so. Mr. S.K. Agarwal appears on behalf of the respondents.
Yes, sir.
Issue notice. As Mr. S.K. Agarwal duly accepts notice for all the respondents and 4 weeks time for filing objections to the interlocutory applications. List the matter on 26th of July 2023.
Machu.
51.
তিনটাতে রে।
Delay in substitution.
How much?
121 days.
First date.
First date.
First date.
Lordship.
You're objecting?
Objecting in respect of only the quantum of days, Lordship. They have asserted in respect of delay of 121 days. But Lordship, the delay is actually of 387 days.
Agor is the order to Nam to BD Deka, Mr. K. Jain.
Yes.
Going to object. File objection 26-7. Same on.
54. Lordship, in respect of objection, in respect of following of delay, I don't have any objection, but the quantum of delay is, separate one, different one. It's not actual.
I'm asking you, are you objecting?
No, Your Honor.
Then we dispose of.
Yes, sir.
Heard Mr. B.D. Deka, the legal counsel appearing on behalf of the applicants, and Mr. K. Jain appears on behalf of the respondents. The three applications being an application under Order 22, Rule 3 of the Code of Civil Procedure 1908, bracket did you IAC 1447/2023 or semicolon. The application under Order 22, Rule 9 of the Code of Civil Procedure 1908, bracket IA Civil number 1445/2003, as well as the application under Section 5 of the Limitation Act 1963 for short, and a bracket of IA Civil number 1444/2023 are taken up for disposal together. A perusal of the said applications revealed who died?
One.
Huh?
One.
Appellant. A perusal of the said applications revealed that the accompanying appeal was filed by 4 appellants. Out of the 4 appellants, who died?
Topon does, appellant 1.
The appellant number 1 expired. Appellant number 1 death upon dust since deceased and expired. Expired on
29/11/20. 29/11/20.
29/11/2022. 20. This aspect of the matter could be seen from annexure. Where is the death certificate?
The certificate is not annexed.
No death certificate.
No death certificate.
How are you saying this? Here it is there. You don't know. Just appearing for the sake of appearing. At annexure 1 to IA number 1447/2023. The applicants herein, numbers 1 Roman 1, 1 Roman 2, and 1 Roman 3, submits that they were not aware about the litigation. And it is only when the counsel inform the applicants about the said litigation. The instant application was therefore filed. The instant 3 applications were filed for condonation of a delay of 121 days under Section 5 of the Limitation Act 1963 for setting aside the abatement under Order 22, Rule 9 of the Code, as well as for substitution of the applicants as the legal representatives of the appellant number 1. Mr. K. Jain, the learned counsel appearing on behalf of the respondents, submit that the delay as mentioned in the application is not 121 days, but more. But however, he submits that taking into account that the appeal is presently continuing with the appellant number 2, 3, and 4, he would not object to the applications. Taking into account the above, this court therefore condones the delay of 121 days in filing the application under Order 22, Rule 9 for setting aside the abatement. This court further sets aside the abatement and further sets aside the abatement on the ground on finding sufficient grounds that the interest of justice demands for setting aside the said abatement. Accordingly, this court therefore exercises the powers under Order 22, Rule 9, 3 for the purpose of substituting the applicants number 1, 2, and 3 as appellant numbers 1 Roman 1, 1 Roman 2, and 1 Roman 3 respectively to the connected second appeal. The registry shall do the needful. With above, the 3 applications stands disposed. Amen.
Fifty-four. It is your lordship. Your lordship, for respondent number.
Yes.
Number 1, 2, and 3, and 6 has appeared. Regarding 4 and 5, steps not be taken.
No steps for issuing notice upon respondents have been taken as yet.
Yes, regarding 4 and 5 steps we could not take. They may be struck off, your lordship, because the grounds are regarding quantum, and 4 and 5 is the owner and driver. 1, 2, 3, 6 are the claimants.
Mr. S. Dr. the learned
Lord,
counsel.
in this case, connected appeal is fixed for hearing on 22/6/2023. Appeal by the claimant. Let the matter may be taken together and.
Madam, let me complete the order. Heard Mr. S. Dr. the learned counsel appearing on behalf of the appellant. Ms. S. Roy appears for
Respondent number 1, 2, and 3.
respondent numbers 1, 2, and 3.
Lordship, I
The
am
learn-
for respondent number 6.
And Miss,
Respondent number 6,
your name?
B. Borman.
Ms. B. Borman appears for the respondent number 6. The learned counsel appearing on behalf of the appellant submits that as the instant appeal is challenging the quantum, the presence of the appellant, the respondent number 4 and 5 are not necessary for the adjudication of the instant appeal. He therefore submits that the names of the respondent number 4 and 5 be struck off. Taking into account the said submission, the instant appeal, the respondent number 4, the names of respondent number 4 and 5 are struck off at the risk of the appellant. Ms. S. Roy, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 had submitted that the said respondents have also prepared an appeal against the judgment and award dated 29/3/2022 passed in MAC case number 1831/2016 by the Motor Accidents Claim Tribunal number 1, Kamrup Metro at Guwahati. Taking into account that the said instant appeal is connected, he therefore submits that the said instant appeal be listed along with the said appeal being
286 of 2022.
said appeal being MAC case number
MSc appeal number 286 of 22.
2020. It has been further submitted that the said appeal is fixed on 22/6/2023
for hearing.
for hearing. Taking in that view of the matter, let this instant appeal be listed along with so and so on 22/6/2023.
53.
One, two, nine.
The office note
Stay.
can be seen.
Yes.
Particularly.
What remains? This is a very old matter, Mr. Goswami.
Yes. No.
Who appears on behalf of or appears submits that he requests 7 days time to take steps and accordingly time is granted.
Step was taken.
It is made clear that
deemed
the
to be served.
petitioner fails to take steps within the period. What are you challenging here?
Oh, my lord, the order rejecting my application for amendment.
What?
My application for amendment, man.
Then why it's laid before the honorable court for orders as per Lozima court? What does it say?
And my lord,
Even
one
the
other thing is, my
edit
lord,
was signed by the other than the agency, they notice to be produced without on the
because this does not
respondent.
reflect the name of any of the council representing the.
You are challenging orders,
Oh, my lord, that is
application
a- that is a
challenging.
Page 35.
Huh?
Page 35. I filed an order, application under order 6, rule 17, my lord.
Why it was rejected?
It was rejected, my lord. He says because I didn't mention the second part. That in spite of due diligence, my lord. That is what he said.
Oh, you filed at the stage of argument. Why?
My lord, I filed it at the stage of argument. Your lordship will kindly see what amendment I sought, my lord. It
What
was
is the
in your
amendment you
only
asked for?
typographical error, my lord.
What
Only
is that
typographical
amendment?
error. It is already there in the body, my lord. Your
Where is
lordship.
that application? Yes. What are you asking for?
My lord, the pata number in your lordship will kindly come to schedule, my lord.
The plaintiff has filed
In
a
page
suit for
23, my lord.
partition in respect of land measuring so and so.
Very, my lord, trivial this thing, my lord. But an inadvertent typographical error, I would say. Nothing to, my lord, change the character of the suit or, my lord, prejudice the defendant in any manner, my lord.
So what you are asking at paragraph 3?
My lord, paragraph 3, my lord.
Come to page 30.
Page 30, my lord. Amen.
What the plaintiff side was preparing for argument. It has come to the notice. Is it English wrong or horrendously clear?
Typographic, oh my lord.
In
Your lordship will kindly
paragraph-
see the amendment, what I have sought. Next page, page 31.
Schedule A, PP number will be
Yes, ma'am.
inserted after the word 432.
Yes, my lord.
In
That is all,
schedule
ma'am.
A3, PP number 181 will be inserted.
And these two,
Inserted after in number 77 in line 2. The figure
my lord,
typed as 11 in line 20 of page
11.
5 of the app will be corrected by 6 more.
yes, my lord.
What is the objection? So,
Objection is there.
Where's the judgment?
The judgment, madam, there are several, madam.
Give me only one.
These are no new facts, man. All are there mentioned in the body, my lord. And then, but it was somehow.
Where's the judgment?
Surendra Kumar Sharma is one, my lord. That is 2009 10 SCC, my lord.
Which one name?
Surendra Kumar Sharma.
For what?
Man, allowing the amendment, my lord, laying down the principles, my lord. Your lordship will kindly ignore my notings there. Marking. Mahila. One is 2015 13 SCC, my lord, 132 Mahila Rampali Devi. Yeah. Well, there are 20 of these judgments. My submission, my lord, if this amendment is in no way they will be affected. In fact, my lord, earlier, my lord.
No, these are not the relevant judgment. Judgment on schedule. You are asking for changing
correction
that.
of the schedule.
Then schedule can be changed
also-
at any point of time.
Yes.
Then where is the judgment? Look, let me get hold of the judgment. Tomorrow at 2. Pass the order. We good? Anything? Which
Hearing,
one?
madam. Supplementary 50. Supplementary 50 hearing. Any day, lord.
Is a hearing?
Lords. MSc appeal lordship any day. 52 and 55.
Huh?
55 I am lord. I'm in both.
You are in both. MSc?
MSc lord. Lordship.
Quantum?
Quantum.
Hello. I'll pass it to Kali. Without.